Good morning, everybody. Happy Wednesday, the 1st of July. This is TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We're going to start with Magistrate Urich, where his first contestant maybe got busted for illegal podcasting. That's kind of what it looks like. Let's find out.
The City of Royal Oak versus David Ortiz Dupree. That's you, sir?
Yep, that is me. Good morning.
Good morning. Mr. Dupree, you were present earlier when the court explained the nature of an informal hearing. True?
Correct.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Correct. I am.
Thank you. Hang on. I got to read the citation.
Sorry. I'm sorry.
I've got a protocol that is required by law. So the citation indicates that on April 26th of this year at 7:07 in the evening, you were operating a 2026 Tesla blue in color on 11 Mile Road, Edinburgh, Woodward, M1. In the City of Royal Oak, at that time, you were cited for a plate that had expired on your birthday in February, and you had made a prohibited turn. So there's two citations. One is documentary, non-moving, and the other prohibited turn. You may admit responsibility. You can admit, explain, and display an updated registration on the Tesla, or you can deny responsibility. And the court will commence your trial. Mr. Ortiz Dupree, what do you wish the court to do?
I'm going with the second option.
Very well. So you confirm to the court that on the date in question, you were operating a motor vehicle in the City of Royal Oak with an expired tag, and intentionally or unintentionally, you made a prohibited turn, correct?
Correct.
Court accepts your plea. What's happening?
Okay. So my wife just got my registration. She's coming back to because I left it in the car. I'm sorry.
Okay.
So I'll display that on the screen when she gets back. So just two things. I do admit responsibility. I did see the officer behind me. Like, he was right behind me when I was making that left turn. I'm 39 years old. For 25, 26 years of my life, I lived in New York. So making that left turn, like, if I thought I was doing anything wrong, I obviously wouldn't have done it. I'm a big supporter of Back the Blue and everything. So, and I've never received a ticket in my life. I don't know if you guys could go back that far. Like, in New York, I've never received a ticket. I've never been pulled over. So having it happen in Michigan and receiving a ticket, like, at least a warning would have been nice. I don't know. Like, I've never received a ticket or anything. I did talk to the officer. He said if I update my registration, he'll come with me. He'll fight it with me. It's fine. But
Keep going.
I'm currently unemployed, and I'm trying to find a job. So I mean, I can't really afford to, I'm kind of relying on my wife right now because of everything going on. But no, if I just hope the court will give me some kind of leniency on this situation, because like I said, if I thought I was doing something wrong, I wouldn't do it.
I understand your circumstances, and the court appreciates your remarks. And hopefully there may or may not be a career for you somewhere in broadcasting in the future.
Oh yeah, I try streaming.
You're tooled up for it. Do you have, Officer Moran, did you check this gentleman's plate?
I sure did, Magistrate. For the expired plates, let's just jump ahead as well. Expired plates, let's dismiss that. Motion that ticket get dismissed. It is updated. And then can you check his driving record for me for the prohibited turn, please?
Sure could. Mr. Dupree, the court has not looked at your driving record until this moment.
Okay. I keep looking out for my wife to come in.
Officer Moran? We don't have a driving record for Mr. Dupree.
Okay, no big deal. Magistrate, motion that ticket get amended to impeding.
All right, Mr. Dupree, impeding traffic is a 0-point violation. Will not appear on a master driving record. That's an acceptable outcome to you?
I appreciate it, yes.
Very well. So the original plea will subsume the plea to impeding traffic. The fine is $175. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30, due within 14 days. Strike that. You're still out there beating the bushes for work. Why don't we mark this due in 28 days? Is that okay? All right. 28 days, 175, and 0 points. You did well.
I appreciate it.
Be well.
Rookie, I tell you, an absolute rookie. He's appearing on YouTube and he fails to shout out his podcast or whatever it is he's doing, not even a plaque in the background with the name of it. That is why he is unemployed. Good morning once again, everybody. TCF Live on the first Wednesday of July. Let's get back to Magistrate Urich.
Calling case number 26, RO03093. This is People versus Aiden Robert Taylor. That's you, sir?
Yes, sir.
Mr. Taylor, you were present earlier when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes, sir.
Thank you, Mr. Taylor. This citation before the court was issued on May 9th. This year, at about 20 minutes of 8 in the evening, you were operating a 2016 BMW silver in color southbound Woodward M1 at or near Chester in the city of Royal Oak. And at that place and time, you were cited for speeding a minimum of 11 to a maximum of 15 miles over. Officer Moran's remark on your ticket suggests vehicle high rate of speed southbound Woodward near Chester. He was running LiDAR, which is the laser, the Vanguard laser version of radar. He got a rating of 65 and a 45 at a distance of 312 feet. But that's simply an allegation, Mr. Taylor. You can admit responsibility in this matter. You can admit and explain, or you can deny responsibility, and the court will commence your trial. What do you wish the court to do for you today?
Admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by a minimum of 11 miles over. Yes?
Yes, sir.
What's happening?
So I have 3 misfires on my car, and there was a lot of traffic, so I don't believe that I was even going that fast.
Okay. If you don't believe you're going that fast, why are you admitting responsibility?
I guess I didn't understand what that meant.
Okay.
I've never
So
had
this is not a criminal case, but admitting responsibility would be more similar to pleading guilty.
Okay.
If you don't think you were speeding, today's your day in court. So I will again suggest to you, the court simply wants to make sure that you understand what your rights are and that the record is clear. So you can admit and explain, or if you think you weren't speeding 11 miles over the speed limit, you have every right to deny responsibility.
All right, then I'll deny responsibility.
Very well. Please raise your right hands. Do you both solemnly swear the testimony you shall give before this court shall be the truth?
I do.
Thank you very much. Officer Moran.
Magistrate
proceeds
on,
first. Go ahead, sir.
nope, you're good. Magistrate on May 9th, 2026 at approximately 7:40 p.m. I, Officer Moran, was in the area of southbound Woodward and Chester. And I believe at this time I was actually positioned to set up my LiDAR right behind the old Pasquale sign. I was there running LiDAR when I observed a 2026 BMW 435 silver and color bearing Michigan plate Edward Mary Yellow 0217. While I was using my LiDAR, I observed that vehicle and another vehicle traveling at a high rate of speed on southbound Woodward near Chester. I positioned my LiDAR and hit the front bumper of the 2016 BMW and got a reading of 65 and a 45 at 312 feet.
Very well. Officer Moran, very briefly, would you care to lay any foundation with respect to your training and experience with that particular unit and how that unit might work?
Yeah, as soon as you turn it on, it goes through a pass or fail. As soon as that unit got turned on that day, it did pass. It was calibrated incorrectly at the station. And then as soon as I shut it off and turn it back on to make sure that it had another pass or fail test at the end of my shift.
Okay. And how long have you been a peace officer?
Over 9 years.
All right. And is this the next generation of radar
LiDAR is more accurate than the radars that are in our car.
Thank you very much.
Yep.
And lastly, this is the LiDAR is not conclusive, so to speak. We're running a hearing here for the fact of trying to assess evidence and make a finding. Was there any other indication to you that the vehicle was exceeding the posted speed by at least 11 miles over?
By visually estimating it, I was seeing vehicles travel at a high rate of speed. That's what brought my attention to bring up the LiDAR and get a reading from that vehicle.
Very well. Okay. The court appreciates your testimony, and obviously you have the right to rebuttal if you choose to use it after Mr. Taylor. So, Mr. Taylor, you're up. What's up?
Going down Woodward, I was behind people who were going 40 miles an hour, so I got over to pass, and I had a Corvette fly up behind me as we were passing that sign. I never went over like 55.
Mm-hmm. Okay. So your suggestion is you were within 5 miles of the posted speed of 45.
Correct.
Okay. Is there anything else you want the court to know?
I had 3 misfires, so I wasn't even able to speed up at any like excessive rates of speed.
What do you mean by misfires?
My engine injectors are like messed up, so it's making the engine run rough. It won't let me speed up in a way. It's in limp mode.
Mm-hmm. Might you have any documentation from a licensed garage that would confirm that?
I have my own personal scanner, and I think I saved the information from it.
Court appreciates those remarks. Do you have anything else you want the court to know, Mr. Taylor?
No, sir.
All right. Turning back to Officer Moran, rebuttal testimony.
Nothing from me, Magistrate.
Thank you very much. The court has heard the testimony of both parties and People versus Taylor. The testimonial portion of this hearing is closed. The court first notes that the burden of proof in a civil case is a mere preponderance of the evidence. This is referred to as the featherweight test in the law business going back over 200 years. Meaning to say, if there were scales before us and a feather was on one side and those scales reflected that feather weight, that would be enough to carry a burden of proof. Secondly, the court always wishes to believe after 40 years in and around the courts in the state of Michigan that the parties are always proceeding in good faith based upon their best recollection and perception of the events at hand. And lastly, the court zero idea what Mr. Taylor's driving record may or may not look like. The court does not review driving records before it undertakes a hearing. The court does believe that that burden of proof was amply met. LiDAR is the newest generation of speed detection in terms of a tool. The officer testified that that LiDAR unit was running correctly, but he also confirmed that the LiDAR is an investigatory tool, and based on his visual, the vehicle was exceeding the posted speed by at least 11 miles over. So the court does find you responsible, Mr. Taylor. The fine is $170 that is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days, and if you wish to appeal this court's ruling, you have absolutely every right to do so by posting a cash bond of $170 within 7 days, and the matter will be placed on the formal hearing docket. At that time, the city would be represented by a city prosecutor. So 170 within 7, and that completes your hearing. Good luck to you.
Thank you.
Timmy, starting off July strong for us. 5 gifted memberships. Thank you so much, my friend. I very much appreciate that.
Calling case number 26, RO 02953. This is People versus Michael Robert Kalinski. Mr. Kalinski, are you available?
Yes, I am.
Very well. And are you able to activate your camera, sir?
I thought it was. I'm trying
Court,
to right
court
now.
doesn't see you, but as you sort that out, Mr. Kalinski, you were present when the court explained the nature of an informal hearing. True?
True.
So you understood the court's instruction that you must select from one of three options to protect your own rights, correct?
Correct.
Thank you very much. The citation before the court indicates that on May 4th of this year at about 8:30 in the evening, you were operating a 2024 Kia, white in color on Main Street at near Lincoln. In the city of Royal Oak, and at that place and time, it was discovered that your vehicle plate had expired on May 1st of this year, which is just coincidentally what they call Law Day. So with that said, you have three options. You may admit responsibility. You can admit, explain, and we can somehow confirm that that plate has been renewed, or you have every right to deny responsibility. And the court will swear the parties and conduct your trial. Mr. Kalinski, what do you wish the court to do for you?
Admit and explain.
Very well. So you confirm to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak, and you had an expired tag, correct?
Yes, correct.
Thank you. Officer Moran, have you checked Mr. Kalinski's tag?
I did, Magistrate. Checked it last night at 6, a little after 6 p.m. Motion that this ticket get dismissed.
All right. Well done, Mr. Kalinski. Let's see here. Well, you got about 30 or 40 summers to go on these birthdays of yours. So you know what to do. Okay?
Yes, I do.
Take care. Good luck.
Thank you.
And let's see here. You may be clear and away, Officer Moran.
I do have 3. I don't know if they're here though, Magistrate.
Lindsay McCloud.
Yep.
Roland Moss.
Yep.
And Ebony Riller.
Yep.
These all appear to be failures to appear. So the court will mark those as such, and that completes your broadcast day.
Thank you, Magistrate. Have a great day.
You will.
Michael, thank you for gifting a membership. Wahoo, thank you for gifting a membership. Appreciate you both. And I'm so upset that somebody by the last name of McCloud failed to appear. I really kind of wanted to see that person. Alrighty, friends, it is TCF Live on this first day of July. Thank you all so much for being with me. Do me a favor and smash or lightly press or love upon that like button. Whatever it is you do with your like button, that's between you and the like button. But we'd love that here. Every like helps the show get found by others and helps us continue to expand. Let's do this. Let's stay in Michigan, but let's go say good morning, Judge McNally.
Stroud. People against Jesse Lee Stroud, 25B149374A.
He's coming in on Zoom, Judge.
Well, he comes in on Zoom. Tim, 5 more gifted memberships. Thank you so much. And Tot throws one down as well. Thank you, Tot. Appreciate all of you.
Okay, I couldn't figure that out because you're building the details. Oh,
Yes.
Thank you very much. Okay, Mr. Stroud, start your video, please, and state your name. How you doing?
Good. How are you doing? Jesse Stroud?
Wow, you're looking good there, Mr. Stroud. You didn't show up for court just like that on Zoom, did you?
Yes, sir.
Wow. Somebody's showing some respect. That's kind of cool to see if you're me. You know what I mean?
Yeah, I understand.
All right. Did you learn anything here?
Yes, sir.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, sir.
All right. Since you were in court and I sentenced you on the order of probation on October 22, 25, have you been arrested for any reason?
No, sir.
Any new charges pending against you?
No, sir.
And you haven't had any police contact?
No, sir.
Well, I wish you well, Mr. Stroud. I'm going to go ahead and dismiss the case on motion of the prosecutor. You were compliant. Good luck to you. Stay
Thank you.
clean now, will you please? Stay for yourself. Okay?
Yes, sir.
Good luck.
Thank you.
Marquita Nicole Collins, 246-246-206. Good morning, ma'am. Your name, please? You're charged with driving on a the right to an attorney. If you want one, I will give you one. You understand that?
Yes.
Would you like an attorney to represent you? Okay, we're going to give it.
I thought we was already explained that I have my license and my insurance, so I thought we had dropped it.
This is just to arrange. We just scheduled this for an arraignment and a pretrial today. You haven't been in front of me on this yet.
Huh?
You've not appeared in front of me on this case yet. Did you?
I believe I did.
No.
Probably.
Was it another one?
Okay, it was another one. She said yes.
Okay. All right. I'm going to go ahead and give you a defense lawyer. You can go out in the hall and we'll set you up, okay? Good luck. Amy.
Barbara, thank you for the $5, thanking people for the gifted memberships, and then throwing down a membership yourself. Appreciate that very much. Thank you.
Mr. Hill here and his client.
Yes.
That's, pardon?
Yes, they're both out here, Judge.
Okay,
You
bring
want me to
them
bring
in,
them in?
please. This is people against Todd Dwayne Johnson. Todd Dwayne Johnson, 26-713-033. Your name?
Good morning, Your Honor. Alex Hill on behalf of Mr. Johnson, P76961. Mr. Johnson, will you state your name?
You have to start your video, Mr. Johnson.
Okay.
Your name?
Todd Dwayne Johnson.
So I got a stipulation from your lawyer in an order to adjourn, a proposed order to adjourn that the prosecutor agreed to. But I did not do the arraignment on this case, and there are some bond conditions that I need to add, okay? There was a visiting judge in here at that time. So counsel, what would you like to say? I understand that the visiting judge gave him a personal bond of $1,000. I have no issue with that. But I do have an issue with, I need to address some bond conditions here besides no alcohol or drugs. So
Absolutely, Your Honor.
can you tell me when his prior was?
It was at least a few years ago. Mr. Johnson, what year was your prior operating?
2020.
2019 or 2020?
2020. Huh. What was the alleged, this is a alcohol case that I'm looking for the breathalyzer or blood result.
I don't know the older case, Your Honor, but I know the present case, the alcohol allegation is relatively low. I haven't reviewed all the discovery, but my understanding is it's around the 0.1 level. But he does obviously understand the concern. He wants to show the court he's compliant with a no alcohol condition.
Over a 2-1 though.
For the first one or this one?
This one.
Okay.
He had a 227 on the first test and a 214 on the second.
That is a concerningly high level, Your Honor. We're not opposed to a testing condition. I don't know if Mr. Johnson is travel-wise to get testing. If, something like 2 times a month random would satisfy the court, but he would have to go, or if he wants to ask for a SoberLink device where he could blow 2 times a day or at the court's discretion to verify he's not consuming any alcohol. Mr. Johnson, do you have a preference between random testing set by the judge or a SoberLink device so that you can not need to go and report for testing on your days?
He's not going to get to, he's not going to get to decide that. Okay.
I understand. Okay, Your Honor. We leave it to the court's discretion, but he is ready, willing, and able to show the court that he's going to refrain from alcohol as this case proceeds.
I'm going to give you a number. Are you at home, Mr. Johnson?
No, I'm actually in my work van like right now.
Okay. Do you have a pen?
I can take it.
Yes, I do. Yeah. Yes, I do. Hang on. Let me grab my notebook here like real quick. Okay, I'm ready.
So, counsel, why don't you write this down too? I'm going to give him $1,000 personal bond. You cannot have any contact with prosecution witnesses except through your lawyer. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to attend AANA at least twice per week. Counsel, if you don't have any AA forms, we will send them to you and you can get them to your client. But you're to immediately start going at least twice per week. And that has to be in person. Also, you must obtain a SoberLink device by the end of today. You must obtain a SoberLink device by the end of today. You're going to have him call this number in the probation department, 734-671-0201, extension 245. They're going to explain to him where he has to go to get that and what kind of cost there is. Heather, I want to know the pretrial date that you've given Mr. Johnson, if you, Mr. Hill, rather, if you haven't, if you've done that already.
July 14th at 9:30.
July 14th at 9:30 will be the pretrial date. So you understand everything I said, Mr. Johnson, correct?
Yeah, yes, I do. The only thing is, as far as the device or what you're talking about, like I'm kind of ignorant to that. I don't even know what that is.
I'll talk to you, sir. It's a
SoberLink device,
Okay.
it's a portable breath machine, and you're going to have to blow into it 5 times per day. Don't miss a test, okay? Or the bond is subject to being forfeited. Understand?
Okay, and only reason I'm asking is because is that something I do it's something I can take with me, so I can take it from my personal vehicle to my work van to personal vehicle. It's something I just carry with me all the time.
Correct.
Okay. All right. Okay. Thank you.
So counsel, call the probation department and set that up and make sure you get them an AA form. If you need any assistance, you call.
Absolutely, Your Honor. We appreciate that.
Okay, and it's Pam's here today, right, Heather?
As far as I know, yes.
If not, you're going to call this extension. What's yours again, Heather? It's
228.
228. Okay?
Thank you, Your Honor. We look forward to moving the case forward on the 14th.
Thank you. Good luck, Mr. Johnson.
Thank you very much.
Salvatore Gabriel Damadio, 26B83910. Right up to this podium, sir. That's all right. Your name? How you doing today? You're charged with animal vicious act. That's a misdemeanor. You also have 2 civil infractions, no dog license and dog roaming at large. You have the right to a lawyer. If you want one, I will provide you with one at public expense. Would you like an attorney? Yes. Okay, you can go right out in the hallway. We'll set you up with a defense lawyer, and then either way, you're coming back in front of me today, okay? People against Shannon Sherelle Phillips, 26B150905A and B. Good morning, ma'am. Your name? Okay. Do you have your discovery yet, ma'am? Everything you need?
No, I just received it yesterday afternoon at about 12.
So you have it now?
Yeah, but I haven't read.
No, I understand. I'm just that's what my question was. Do you have everything that you need?
Yes, I just got the email. I didn't really go through it. I think like 4 attachments. But yeah, I did receive discovery.
Okay, so we'll go ahead and you can review all that. I'll give you a 2-week adjournment. We'll set this for July. What are we doing? The 15th, Heather?
Yes, July 15th at 10 o'clock.
And you still don't want an attorney to represent you?
No, sir.
Okay. July 15th at 10. If you change your mind, can you afford your own lawyer? I'm just curious.
Yeah.
Okay. Okay. All right. So if you can afford your own and you decide to hire one, bring him or her with you. If you decide to represent yourself, that's fine. I'm still going to suggest you get a lawyer, but you do what you want. You have the right to represent yourself. Okay?
Yeah.
Go down the hall. They'll give you a paper notice. Good luck. You're welcome. Fleming. Dardanian Kenyatta Fleming, 26B 14998 and B. How you doing, Mr. Fleming? Good. Your name? Hey, just keep your voice up nice and loud for me, okay? All right, you have a charge of trespassing and consuming recreational marijuana in public. That's a civil infraction, the recreational consumption of marijuana in public. The trespass is a misdemeanor. You have the right to a lawyer. I'll be happy to provide you with one if you would like one at public expense. Would you like an attorney?
Yes.
Okay. I'll get you a lawyer. Just remember, you have to enunciate everything and keep your voice up when you come on back, okay? So we're going to set you up with an attorney as well. And after you speak with your lawyer, you come on back in with your lawyer. Okay, good luck. Is Mr. Courts ready on his sentencings?
He was working with some was fine.
Mr. Courts, are you ready?
Yes, I am.
Bring your client in, please. Morning to you. People against Jacob Michael Douglas, 24B1470488.
Good morning.
Hang on one second. I also have 24B1470755B and 24B1470448B. All right. Good morning.
Good morning, Judge Anthony Thomas Courts. Here on behalf of the defendant, sir, can you say your name for the record, please? Good morning, Jacob Douglas.
All right. So let me just recap here. He pled guilty to operating while impaired due to the consumption of drugs. He also pled guilty to failure to report a property damage accident. The original charge of operating while intoxicated due to the consumption of drugs or operating while with the presence of drugs was dismissed, and as was the leave the scene of a property damage accident. He also has an outstanding civil infraction in front of him that he did not pay dating back to 2023. I mean, it was the same date. They've got a different case number. It's just 7075B instead of, I'm not sure why they were not consecutive here, but at any rate, so I referred him for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Judge, while it was accurate at the time, there are two updates I'd like to share with the board.
Okay.
His employment status has changed. Instead of working at Arby's.
1 second, Amy. Okay, instead of working at Arby's part-time, he's what?
He's now working, doing gutters. He's now doing gutters at Gene's Construction.
Okay, I'll modify the report in that aspect.
And then, Judge, there's also, his 2-year-old child. The mother has lost her job, and so now he is providing assistance and help with.
Okay.
Besides that, Judge, we believe the report to be fully accurate.
All right. Anything you would like to say on his behalf?
Judge, thank you. The case is from 2023. That's not the behavior, but it is to say, Judge, that there's a slightly different person that stands in front of you. He came to court today. He's voluntarily trying to handle his legal matters. He's working. He's employed. He's got a child. Back in 2023, he didn't have a child. My client, this is a drug-related problem, and he's telling me that if we were to test him today, he'll test positive, Judge, which really changes the whole dynamic of the.
He will test positive?
Oh, I'm positive. Sorry about that, Judge. He's positive that he would test clean.
I don't usually expect defendants to come up here acknowledge that they've violated a bond condition, so I'm glad to hear that at least, but go ahead.
Thank you. So he's, so I would ask Judge that he be put on probation because the underlying drug problem wouldn't be treated.
What happened with his assault with intent to do great bodily harm, less than murder probation violation out of the Third Circuit Court? Does he still have that outstanding?
He has that, Judge, but we are handling that. I am going to take on the case of Taylor where that violation came out of, and we are going to go to front of Judge Casca, preferably this week, and turn him in on a warrant. He wanted to come and take care of this, but we're going to take care of that warrant and tell the judge we're fighting that case, Judge.
Okay, why isn't he showing up on that? The date of that warrant was only June the 18th, but nonetheless, he received notice. Why didn't he show up?
Judge, I don't have a good explanation for that, but we can go there immediately. I'm going to circuit court right after this, Judge. If you'd like, I can take him with me and turn him in for his warrant.
Okay, go ahead.
Thank you. And that is all I'd like to say on my client's behalf at this time.
What are you doing? What are you doing? I don't know how many chances you think you're going to be given. I get the fact this is a first drug or drunk driver. I'm not looking at things in an isolated fashion like that. You got a big problem. Well, I'd like to believe you've changed, but it's hard for me to believe you've changed when you had assault with a dangerous weapon in 22. Granted, this is a 23 case. Then you were convicted of assault with intent to do great bodily harm and felonious assault. Another count of felonious assault in the Third Circuit. Then you had an aggravated assault out of the Third Circuit. So they must have pled that down from initial felony. Then you were arraigned on a charge. You have a case out of the 23rd District Court for malicious destruction of property. Now, that's just an arraignment. Maybe you weren't even there. It might not have been, it might have been somebody else. I don't know. Then you were arraigned on a charge of domestic violence out of the 23rd District Court on a charge of domestic violence, same date from the MDOP. Also arraigned on a charge of assault and battery out of the 23rd. Now, again, maybe you're innocent in all those. Maybe you were out of the country and somebody used your name. I have no clue. But you're not doing too good. You leave the scene of an accident here.
A lot of that stuff happened before I had a daughter. That was 2023. My daughter was born 2024.
Didn't happen before 23. The only thing that happened before
23.
This one and the felonious assault from 22 happened before you had your daughter born.
Yeah.
And it doesn't even sound like you spent a lot of time because, correct me if I'm wrong, this claims paternity to a 2-year-old daughter, but reports not paying any child support or being involved in the child's life. That's what you told probation. Is that true or is that a lie?
That's not true.
You told them you weren't involved in your child's life?
Well, at the time, I was working at Arby's and I had got a good job.
Hang on a second. Let's slow down. You just started on this case on April the 20th, right?
Yes, sir.
You reported at the time of the screening, which was on June the 17th, which was only 2 weeks ago, right?
Yes, sir.
You reported all of this to the probation department,
Yes.
right? And now you're saying, well, my life changed when I had my daughter, even though you had the daughter in 24 and all these other events have happened in 25 and 26. And now you're making it sound like you changed in the last 2 weeks.
Well, a lot of those things, the crime was committed in them years. I wasn't convicted until
I don't want to hear anything about the charges. All I know is the probation department is recommending jail, and I don't blame them. And I'm only talking to you because I'm trying to figure out how I can rationalize in my brain not sending you to jail.
Yes, sir.
Can I speak just quickly, Judge?
Sure.
As this case relates, just as this focused case is about drugs, I would argue that this case would be better treated with probation. And those other instances, Judge, you're definitely, of course, right to take note of them. But he's going to have to answer to Judge Casca, who specifically handled that case and that violation. And deal with the judges and Taylor for the underlying facts. Judge, I would just ask for the mercy on this case to let him have probation. And if the facts of those other cases, when they're fully fleshed out, warrant jail, I'm sure the circuit court will issue that.
Look at all these substances you had in your system. You had no business driving. No wonder you drove into the utility pole. It's a good thing you didn't hurt yourself or somebody else. Then you left the scene. Then you ignored the court. You didn't show up. You're lucky. You are really lucky. You know why you're lucky? I'm not going to take into account any of these new charges where there had not been convictions. That's not appropriate for a judge to do. I'm not going to do it. That's not appropriate. That's not the way our system works. Or should work anyway. But you are going to be on a short leash with me. And I am going to trust, Mr. Quartz, that you are going to take him down. You said you were taking him down today?
Yeah, well, as long as he has no objection, you can ride with me and I'll take you down there right now.
Are you going down there? Because I'm going to order you to go.
Yes, sir.
And if you don't go, you're going to serve 93 days. And you tell Judge Kask I said that.
Yes, sir.
All I know is I don't like the way your life is going so far for you, not for me. But if you end up in poverty, it's no skin off my neck. You don't have a diploma. You don't have a GED. You're making $250 per week. Maybe this job's going to pay you more. You fathered a child. You had nothing to do with the child. That's bad. I can't stand that. I think any man that impregnates a woman, if you don't take responsibility for that child emotionally, financially, well, then you got a lot of answers to give yourself when you look in the mirror the next time. But I'm not going to penalize you for being a bad father. I'm not a social worker. I'm not a priest. You are on such a short leash with me, you have no idea. On the drug driving, the operating while impaired due to the consumption of drugs. This is the sentence of the court. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. By the way, do I have proof that he attended AA? NA? Did you show it to your lawyer?
I did not, but I do have.
Show it to him. I expect to see that you've gone twice per week since June the 17th. If there aren't at least 4 on there, I hope you brought your toothbrush.
Judge, just for full disclosure to the court, so far there's only one listed, but we'll get them there, Judge.
Okay? You're not taking it seriously then. And I don't want to hear any more. She talks cheap to me. Had you gone to AANA, I was not going to send you to jail. Now you lose.
Well,
Now you lose. I don't want to hear another word. I don't want to hear another word. I'm not going to listen. Tells me you don't take courts very seriously.
appointed today to go to a meeting. I was
Too late. Too late. Too late. Too late. 24 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing, PBTs, and ETG tests. That'll be weekly for 3 months. If you are clean, it will then be bi-weekly for 2. If you are clean, it will then be monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to obtain and maintain employment and provide proof. You're to obtain a high school diploma or a GED. You're to attend AANA twice a week until you are in an outpatient substance abuse treatment program. Once you get in outpatient substance abuse treatment, you no longer have to attend AANA. You're also to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. Defendant to surrender to the Wayne County Circuit Court for probation violation hearing on warrant entered June 1826 within 2 business days of his release from jail. Now expect proof of that. You are to serve 12 days jail credit 1. You're going to serve 6 now, and you're going to serve 5 more days on the court work program pursuant to the probation order. There's a $35 a day charge for that, for a total of $175. You're to pay fines of $300, costs $250, $75 victims' rights fee, $50 justice assessment, that's $675, screening fee $60 for $735, probation fees are $40 for $1215, plus your court work program fees. The total is $1390. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. On the failure to report a property damage accident, I'm simply going to go 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4, 5 days court work program. Court work program days concurrent with that I imposed on 25B147048A. I will simply go out of my way and give you credit for time served on the no proof of insurance. Defendant given credit for time served on the no proof of insurance, Heather, but he still must pay the clearance. So you're still going to have to pay your $45 clearance fee. Now, he doesn't have any money today, does he?
I don't believe.
You don't have any money.
I have a few dollars on my channel. And like I said, I've been working endless hours.
Okay, good. Do you have enough to pay the failure to report a property damage accident? That's 3 1/4.
No.
How much do you have?
I'm pretty sure I have like $100 on my channel.
So you're sure you can pay 100 today or not? Just tell me the truth. I'm not going to penalize you anymore.
I think it's like $90 a month.
You pay $90 now on that. Then you're going to pay $30 per week on that case beginning on July the 31st. If you don't have the money, you call the court. We'll go on Zoom on or before the due date at 8:30, or you can come in and talk to me on or before the due date at 8:30. Then you're going to pay on the other case, the operating while impaired due to the consumption of drugs. You have a bond of $5,000, 10%. I'm pretty sure we can apply that with the 10% because he's not been discharged from obligations with the court. So you're going to pay $450 now on that and $30 weekly after fines costs paid on 7048B. You are in custody for the next 6 days. I'm not going to change my mind. Maybe next time you'll understand you're going to comply with my orders. If you don't, you're going to end up going back. It's time for you to grow up. You're 22. Get away from this criminal activity. Start acting like an adult. Good luck. Thanks, Mr. Court.
Thank you, Chris.
Alrighty, friends, it is TCF Live on this lovely, lovely Wednesday. Ellie's come up to say hi to you all, and now she's stretching and walking away. We'll probably come back to Judge McNally soon, but let's head down to Florida, as we usually do, and check in with Wade Mercer.
You've been accused of 1 count of perjury. Mr. Jones, there is probable cause in a complaint. So I've read that complaint. I've also looked at your criminal history, Mr. Jones. I know that we're in jail for something else. What's not on here and what I did not look up is whether you're in jail with a pending charge or whether you're in jail serving a sentence.
Child support.
Oh, it's a child support. So it's a civil matter. Okay. So, Mr. Jones, I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys before I set that bond, and we'll see where it goes. Mr. McDaniel, anything on behalf of Mr. Jones?
Nothing else, Sean. Nothing.
Mr. Mitchell.
Your Honor, we just want the court to take into account that this is relating to a testimony he gave in a life felony case that occurred last week. It should be important to note that because of this perjury, it was very fundamental to that case at the time. And basically I'll just leave it at that. But the state is asking for a high bond given those circumstances.
The complaint says it's just a second, Mr. McDaniel, I'll be glad to listen to you. The complaint says it's a 3rd-degree felony. Are all perjuries 3rd degree, or is there a 2nd-degree version? Let's look and see.
I think there's a third. I think it's just 3rd degree.
837.02 is the Florida statute.
Like under oath perjury.
Go ahead, Mr. McDaniel.
I think it's misdemeanor if it's not under oath. Like statements of law enforcement officers,
That's right. If it's related to a capital felony, it can be 2nd degree. Otherwise, it's going to be a 3rd degree if it's an official proceeding. Okay. It's 3rd degree felony. All right. Mr. McDaniel, anything else you wanted to add, sir?
Your Honor, we just asked for a normal bond. Obviously, this is a case that the state took extremely, somewhat personal, it seems like. I would think they would have interviewed the witnesses, prior to testimony be going on over. And his was told me he was not lying. He just don't know. So we just asked the court to take those things into consideration.
Okay. Thank you both. So I'm going to set your bond at $7,500, Mr. Jones. It's cash or surety. Obviously, there's no point in posting it unless you post the purge in your child support matter. But if you post the purge in your child support matter, or if you finish that sentence, you are eligible to post the bond here, Mr. Jones, and you get a chance to use the phone, sir, to try to contact friends or family and let them know what's going on. We've got a young lady coming in the courtroom. Let me make sure she's not on this case. Ma'am, what case are you here for? Okay. Mr. Jones, also the jail will give you a notice for your court date. That court date will be August 4th at 8:30 will be your notice. They'll give you that in a few minutes. Mr. Jones, do you have any questions?
No, sir.
All right, sir. Wish you the best. Jerry Franklin. And your relationships, I can tell them who's here, ma'am. Mr. Franklin, good morning. Mr. Franklin, your sister is in the courtroom. You're here because you've been accused of 1 count of battery, 2nd or subsequent charge. That's a 3rd-degree felony. Mr. Franklin, there is probable cause in the complaint, and it looks to me like you got out of prison, I believe, in December, about 6 months ago. Is that right, Mr. Franklin?
Yes, sir.
So I think you're entitled to a bond, though, as far as I can tell, because you're not on probation, and it doesn't look like you have any charges pending anywhere. So I'm going to listen to the attorneys, and I'm going to set you a bond. Mr. McDaniel, anything?
Nothing, no.
Mr. Mitchell?
Nothing, Your Honor.
Mr. Franklin, on this misdemeanor, your bond's going to be $3,500 cash or surety. You have a condition, no contact with the alleged victim, Mr. Franklin. The jail will give you a notice for your court date, which will be
The 4th.
the 4th of
August 4th.
August 4th at 9 a.m. will be your court date.
It's a felony.
August 4th at 9 a.m. will be your court date. They'll give you that notice. You will get to use the phone in just a few minutes, sir, to try to post the bond. Just have no contact at all with the alleged victim. Let me see if your sister has any questions first. Ma'am, do you have any questions? I said it's bond at $3,500. So if he goes through a bondsman and they charge him 10%, it'd be $350 to get out of jail. Yes, ma'am. Mr. Franklin, do you have any questions?
No, sir.
We should have
This is
been,
at
sir.
4 years at 8:30, Your Honor, not 9, but that's, we got it right.
Oh, did I say 9? Yet 8:30. Sorry about that. Thank you. Thank you, Mr. McDaniel. We have Zahir Kalfani. I maybe are mispronouncing that. Actually, I've got it spelled a couple different ways. Maybe Kalfani. Sir, how do you spell and pronounce your last name?
Kalfani, Khalfani.
Thank you. Thank you, Mr. Kalfani. So Corporal, the jail sheet is wrong, but the rest of the jail paperwork looks right. Mr. Kalfani, you're here because you've been accused of one count of Medicaid provider fraud between $10,000 and $20,000, between $10,000 and $50,000. There is probable cause in this complaint, Mr. Kalfani. I'm going to set your bond. I think you're entitled to one. As far as I can tell, you're entitled to a bond. But before I set that bond, let me listen to the attorneys, see what information they want to make sure I'm aware of. Mr. McDaniel, anything?
Nothing.
Mr. Kalfani, I'm looking, I don't see any prior criminal history, so I'm just want to ask you, have you ever been charged with a crime anywhere before this?
No, sir.
That's good. Thank you. I didn't think so. I just want to make sure. Mr. Mitchell?
Nothing from the state, Your Honor.
Mr. McDaniel, is he preferring a cash bond or a surety bond?
Cash bond.
Any objection to a cash bond, Mr. Mitchell?
No objection.
I'm trying to see what degree crime this is that he's accused of. If it's third or second degree. And with no history, it's not going to make a whole lot of difference. I'm going to set you a $500 cash only bond since you're requesting a cash bond because your criminal history is not bad at all. And it's a nonviolent crime. Your criminal history is actually perfect before this. Your bond is $500 cash. The jail will give you a notice for your court date. The jail staff will, that is. That court date will be August the 4th at 8:30. And you will get to use the phone in just a few minutes, sir, to try to post the bond. Mr. Kalfani, do you have any questions?
No, sir.
All right, sir. Wish you the best. You'll see Judge Garcia August 4th. We have Evan Bagwell next. Mr. Bagwell, good morning. Mr. Bagwell, you're here because you've been accused of one count of failure to register as a convicted felon in the county of your residence. Mr. Bagwell, I read the complaint. I had some probable cause questions, more technical issues than anything else. Mr. McDaniel, what's your position on that?
Just ask for a reasonable bond, Your Honor.
So you're not,
ROR possibly. My first day back to work was Monday, so I don't exactly have a lot of savings saved up. I wasn't even aware that I was pregnant. Okay.
okay. So let me first, Mr. McDaniel, just to be clear, I think there's a significant issue, but it's a technical issue with the complaint where they never say he's a convicted felon. That's an element of the crime. So you're wanting to get him a bond today and waiving that issue. Is that right, Mr. McDaniel?
Correct.
Okay. So Mr. Mitchell, I'm going to ask you to notify the officer that being a convicted felon is the element, because that statute covers felons, sex offenders. It covers 4 or 5 violent career criminals. It covers a whole bunch of people. So he doesn't say what his position is that Mr. Bagwell is. Now, I know what Florida Department of Corrections website says, but that's got to be in the complaint. So, Mr. Bagwell, I'm going to find that Mr. McDaniel is not objecting to the probable cause concern, and the reason he's not is he wants to get you a bond set today. So now that that's dealt with, let's go ahead and move on to the bond issue. I've looked at your criminal history, and I think you got out of prison, Mr. Bagwell. Actually, I didn't write it down.
It was February 2nd, 2020. Last year, February 2nd of last year.
Of 2025.
Yes.
And at that time, you registered in Bay County. You did register then, according to the complaint. There's just no evidence of you registering in Jackson County. That's what you're accused of.
I just met a girl.
Don't comment on what you're accused of because we're being recorded and your attorney doesn't want you to say anything that's going to hurt yourself. So I'll be glad to give you a chance to ask questions, but I don't want you to say something that's going to hurt yourself. So for bond purposes or other release options, Mr. McDaniel, anything else on behalf of Mr. Bagwell?
Nothing, Your Honor.
Mr. Mitchell?
Nothing from the state, Your Honor.
Okay. Mr. Bagwell, I'm going to set you the normal bond I would set for this charge, which is $5,000 cash or surety. Now, cash or surety means you don't have to come up with all the money. You can go through a bondsman. That's what a surety bond is. 10% of $5,000 is $500. So that's probably about what it would cost you to post a bond in this case. You have a condition to register in compliance with Florida law. If you do post bond, you need to register in compliance with Florida law, whatever that is, it is. And the jail's going to give you a notice for your court date, which should be August the 4th at 8:30 a.m. You will get to use the phone in a few minutes. Now, do you have any questions?
Yeah. No, I'm sorry.
No questions? All right. Have a good day, sir. You get these phones shortly. Juan Campisi is next. Mr. Campisi, you're here because you have been accused of one count of lewd and lascivious molestation of victim less than 12 years of age with an offender 18 years or older. Mr. Campisi, there is probable cause in this complaint. I also took a look at the Bay County case that happened after this charge allegedly occurred. Once the warrant was issued, there was a Bay County case that resulted where you allegedly fled from law enforcement. They ended up finally arresting you, and then you've now pled to that and been placed on probation. So I took a look at that case also just to give me a little more information. As far as I can tell, you're entitled to a bond, but I want to listen to the attorneys before I make that final decision. Mr. McDaniel, anything on behalf of Mr. Campisi?
So, Your Honor.
Mr. Mitchell?
Usually the standard conditions we ask for with this fine is absolutely no contact with the victim and no unsupervised contact with any minors. So that's what we're requesting.
Okay. Mr. McDaniel, anything on those requested conditions?
No issues, Your Honor.
Mr. Campisi, I'm going to set your bond at $100,000 cash or surety. It's a very serious charge, and the Bay County case leads me to believe you may be a flight risk. Mr. Campisi, I'm also going to have a condition on your bond of absolutely no contact with the alleged victim at all. Doesn't matter if it's supervised or not. And then no contact with any other minor unless it's actively supervised by a person responsible for their care. So if you've got a niece or nephew and you're at a family event and the parent is there present at all times, that's fine. It's got to be supervised by someone who has responsible for their care present at all times. The jail's going to give you a notice for your court date, Mr. Campisi. It should be August the 4th at 8:30. And you will use the phone in just a few minutes, sir, to try to post the bond. It's cash or surety. That means you don't have to come up with all that money. You can go through a bondsman. Do you have any questions, sir?
So 100,000 will be
$10,000 if you go through a bondsman. They charge you 10%. We have Gregory Kennedy.
And Your Honor, right quick, I'll go ahead and notify you. I just texted the sheriff's office. They're going to amend that complaint for Mr. Bagwell.
Thank you. It's a technical thing, but it's the right way to do it is to put in there. The right way to do it is to put in there. He was convicted of a felony on such and such date in such and such county. That's our state. Thank you. Mr. Kennedy, good morning. You're here because you've got a couple of issues. You had an outstanding violation of probation warrant in case 23594 CF. Now you have an additional new charge of possession of controlled substance. There is probable cause for that new charge in this complaint that I've read. So I think in one case you're entitled to a bond. In one case you have no bond already set by the circuit judge. So let me deal with the new case first. Mr. McDaniel, anything on the new case on the bond you want to be heard on?
No, Your Honor.
Mr. Mitchell?
Just the standard random UAs.
Thank you. Mr. Kennedy, your bond on the new charge of possession of controlled substance will be $10,000. You have a condition of random urinalysis on that bond. Mr. Kennedy, don't try to post the bond because you've got no bond in the VOP set by Judge Garcia. So even if you post a new bond, you won't be released because you've got that no bond hold. I want to go ahead and arraign you and get you a lawyer appointed in that VOP if you want one. Mr. Kennedy, do you want an attorney appointed to represent you in that case?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Mr. Kennedy, listen to Mr. McDaniel, and then we'll see if you have any questions in just a minute.
Your Honor, we're going to plead not guilty. Yes, set this on August 4th court docket, and I advise him to be attorney come out and talk to him, or they'll talk to him on August 4th.
Thank you, Mr. McDaniel. Or Mr. Mitchell, anything?
No, Your Honor.
So August 4th will be your court date in the VOP, Mr. Kennedy. It's also going to be your court date in the new charge, and the attorney's office should see you on or before that court date. Mr. Kennedy, you still get to use the phone to explain to friends or family what's going on with your case. So you will get to use the phone in just a few minutes. Do you have any questions, sir?
No, sir.
All right, Mr. Kennedy, wish you the best. Mr. McDaniel, I think that's it on my list. Anybody else I may have missed?
No, Your Honor.
Thank you, Mr. McDaniel.
TCF Live on a Wednesday, now available at normal cruising altitudes. Thank you, Ashley, for joining us during your flight. We appreciate you checking in with us. Let's go back to Judge McNally. Check back in with him.
Good morning. I hope I didn't scare you after that one. Your name?
Charles.
All right. Okay, you're going to plead impeding, right?
Yes.
Responsible or not responsible? Please accepted, speeds dismissed, 170 is your total. You can go down the hall and take care of that, and you're all set. Good luck.
Okay.
Stephen Lee Miracle Jr., 25B148937. Morning, sir. Your name?
Stephen Lee.
All right. You are charged with larceny. You have the right to an attorney. I'd be happy to provide you with one at public expense if you would like. Okay, we'll give you a lawyer. You'll go out in the hallway and we will set you up with an attorney, okay?
Thank you, Your Honor.
You're welcome. Good morning.
Morning, Judge.
What are you here on?
Oratoris Johnson, the sentencing, I'm ready for that.
Perfect.
This one.
Oratoris Johnson, Oratorius Brandon Johnson, 26B150198A and B and C.
GOP 8237, we only have Mr. Johnson, station.
Oratoris Johnson.
He's another one that gets himself in a lot of trouble, huh? I mean, these are suspend, I guess, just going back to 16, but what's he doing with opiates that weren't prescribed? I mean, he pled guilty. I'm not going to take it under 7411. He's got another case where he had one. I'm prohibited from doing that. He's got another drug conviction. I don't know if we covered that, but I'm not going to take that under 7411. It's good.
Never had any.
2014. I didn't say pills. I don't know what it was.
Yeah, it was marijuana.
2014.
I can't do it. So if you want to go talk to the prosecutor again, you can. If you want to tell me, Judge, we'll just accept that as a plea as charged. That's fine. I will still honor the other charge, the resist and obstruct under 771.1 that he pled to. And that was back on, what day did I take that plea? What day did I take that plea? I wasn't very good with noting this, Heather. Heather, it looks like on June 17th. So I took that plea.
Yes, Judge, it was.
June 17th. And you can just tell me what he wants to do.
He wants to move forward with the sentencing.
So you acknowledge and understand that this conviction for possession of a controlled substance will go on your record, that I'm not going to take it under section 771, I'm sorry, section 7411. The conviction will immediately enter. It will be on your record, and it's not going under that statute, and I will sentence you on that case. Do you agree to that?
Yes.
And you acknowledge I need not take a plea again, counsel?
Yes, Judge.
All right, I'm just give me a second to make a note. Case not taken per 7411. Please make a note of that, Heather, because defendant had prior drug charge in 2014, prior drug conviction in 2014. So I'm just going to go ahead and sentence you anew on that. And with that, counsel, we have a plea as charged, possession of a controlled substance. We have a plea to resist, hinder, and obstruct an officer. And that's going to be taken under section 771.1. And then there was an expired plate charge that the prosecutor agreed to dismiss file C. So I'm only going to deal with files A and B. Have you had a chance to review the report with them, and are there any material additions, corrections, or deletions?
We have, Judge, there are no additions, deletions, or correction.
Anything that you would like to say on his behalf?
Yes, Your Honor, as the report said, he is employed, he has a couple of children. I would ask for the court, if the court is going to order any days on that court work program, if the court would take into consideration that Mr. Johnson does work full time. He does like to spend time with his kids on the weekends, so I would just ask if the court would take that into consideration. Other than that, I would ask if the court would adopt probation's recommendation.
Anything that you would like to say?
Apologize for the time that I took to work. I do have a 1-year-old and a 4-year-old that's autistic, which I take care of. The mother is not working at the time. I don't do any drugs. Everything I have done is marijuana. I have a marijuana card. The pills that I did have in the card that was in my possession, but I don't take any type of restrictive pills or I don't drink alcohol or anything like that. And I do agree with what you said, the other case about violence, so I just want to let you know.
Well, I want to, that's nice to know, but why would you have possession of something if you don't use it? Why would you have possession of opiates that were not prescribed to you that you reported you obtained from another individual? Why would somebody acquire something? You have to take your hat off, please, sir. Why would somebody acquire something and have it in their possession if you're not going to use it?
At the time, Your Honor, there was the person that was fixing on the car that wasn't mine. It was a new car. When I was dropping the car off, I was taking everything out of the car and I did put them in my pocket. The person who prescribed me had a prescription for them. And at the time, I did have an eruption of eardrum things, and they wouldn't prescribe me anything.
So you were just going to self-diagnose?
Yeah, they only gave me some antibiotic drops. So that was in about the pain. Never got a chance to take. I didn't even know exactly what they were, so I didn't have any intention on like having look or not. But I haven't taken any type of other medication in years.
So you drive out to Ann Arbor every day?
Yes, sir. I work for a nonprofit in Ann Arbor. Recently, I've been there about 10 to 11 years. Drive about 40 minutes from Trenton to Ann Arbor.
And are you primarily, you still reside, correct me if I'm wrong, with the mother of your children?
Yes, we've been together about 15 years.
Okay, so does she work?
She was working for.
I didn't ask you.
Oh, no, not right now. She's not working. We have a 1-year-old that she's taking care of full time, and so she's not working.
You gonna straighten out your life here?
I thought I had. I haven't been in trouble in a few years, so I think been.
Then you tried to evade the police, right?
No, actually,
You didn't try to evade the police? You told me at the time of the hang on. I asked you what the basis for the resist and obstruct was. You said you didn't stop when you knew they were trying to pull you over. Do you want me to go listen to the tape?
No, you're not there.
Well, is that what happened or is that not what happened? I'm not trying to trick you. I just don't want you to come up here sounding like a choir boy when you tried to evade the police. They could have charged you and should have charged you with fleeing and eluding. You got it? Can we agree to that? I don't want him just to tell me he agrees if he doesn't agree. I'm not trying to trick anybody here. That's not what my purpose is. I just want to have a discussion with you and try to figure out why I think that you're going to do better. And I can't say I see a lot of reasons on that right now. All right, counsel, what else? Anything else that you want to say? I mean, if I'm missing something, feel free to tell me, Judge. I don't think you're looking at this right.
So, Your Honor, that night it was dark outside. Mr. Johnson did see police. I don't think it was an intentional invasion at first. It was he thought they were behind somebody else, but it was dark and you got all these police lights behind you. So once he realized it, which was a mile or so later, he did pull over, but it wasn't an initial, I'm going to run from the police.
Well, at some point he had that mindset. Is that true or false? If it's false, then I shouldn't have never have taken the plea. Right?
It was a situation, again, Judge, it was dark. You got all these.
I know, but I'm just asking you, if he wants to withdraw his plea because he doesn't think he did anything wrong, I thought at the time he told me he drove when the police were following him, and I'm not trying to, listen, I'll let you withdraw your plea right now if you want. If I made a mistake by accepting a plea that I shouldn't have accepted, I'm gonna let you withdraw your plea.
Yeah.
I thought you told me at the time of the plea because I couldn't understand the basis for the resist and obstruct because you didn't provide me any in the beginning, was that you knew the police were coming after you and you continued to drive. Did you tell me that or not? I'm just asking you, did you tell me that or not? I know how I do things, and I know I don't take pleas when there's not a factual basis. I know I don't do that. If I do, I've made a mistake. And if I've made a mistake, I'm going to rectify that mistake and allow you to withdraw your plea right now. And I'm serious about that. In fact, I'll let you go talk to him about that. I'll be glad to do that because I don't want to take a plea from anybody to anything that's a criminal charge of any kind if they didn't commit the act. And I thought that's what he told me. If I misunderstood, it's my fault. I'll accept responsibility. I'll let him withdraw his plea. We can go back to square one and you can go back and negotiate with the prosecutor. But I thought I heard him say that. If he didn't say that, then that's my fault.
Well, Judge, I think what he said was he knew they were behind him and he should have pulled over. I guess even just to be sure that they were behind him. Let's speak to him.
I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first and make sure that we think that you're guilty of that offense? Because if I misunderstood what he said to me, I do not want to go forward with the sentencing on the RNO. And in fact, if he's not guilty of that, maybe the prosecutor can reevaluate and decide she wants to dismiss that case. I don't know. But I'm not going to take pleas and then have somebody come in at sentence and tell me something different than what I thought they said. So if he said something that I misunderstood, my fault, I take responsibility, and you guys can go back and talk to the prosecutor. But I think you should talk to your lawyer before you say another thing, okay? And again, so you got two charges, and if he doesn't feel like he's guilty of the RNO, I don't want to plea. Okay? Thanks. Raymond Lawrence, winner the second, 26B151596.
Good morning, Your Honor. Deanne Fitzgerald, 82378 on behalf of Mr. Winter.
Raymond Lawrence, what to say?
Good morning, sir. This charge here is a malicious destruction of property, and you're requesting a bench trial, is that right?
Correct.
You have the constitutional right to a jury trial, sir. If jury trial, 6 people would be impaneled, all 6 would have to agree that you are guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand?
Yes, sir.
You wish to waive your right to a jury trial?
Yes.
Anybody in the world force you to do that?
No.
I'll accept the waiver. We'll set it for bench. What do you have for me, Heather?
Judge, do you want to do this bench trial on one of our Wednesdays or one of our Thursday Brownstown days? Or do we need to do it when Miss Patillo's here?
Miss Patillo's here on Thursdays?
I don't know if she has any Thursdays with us.
No, I don't. I have some Wednesdays, no Thursdays, and 33rd.
Can I get you to come in on a Thursday, or do you not have?
It depends on the date.
How about how do I look on the 16th, Heather?
Where's
that?
I'm on another court.
How about on the 30th?
We don't have Brownstown on the 30th.
I don't have Brownstown on the 30th?
No, we have them on the 16th.
I thought I had them every 2 weeks.
I don't have them on our docket for the 30th.
And the one Thursday a month, you have Brown.
I see. How about, what do I have on the first Thursday in August? Can I do it then or not?
We actually don't have them until August 20th.
I'm sorry, Heather, I didn't hear you.
We don't have them till August 20th in August.
I can do August 20th. Are you available?
Yeah, actually, I am.
I'm here that day, right?
Yes, you are, Judge.
I'll do August the 20th. August the 20th at what time, Heather?
Since it's a bench, do you want to do it at 11?
Sure. 11 a.m. on August the 20th, okay? So, sir, you'll go down the hall, we'll give you your notice, and we'll see you on August the 20th. Any questions? Anything else on that, Ms. Patillo?
No, thank you.
You want these files back on the other one, or you want to just go talk to them? Thank you. Okay, Lillian J. Star, 26B150733A and B. Good morning, counsel. How are you?
I'm doing well, Judge. Kenneth Camilleri on behalf of Julianne Trotter, Your Honor, who's sitting to my right.
Okay, I'm getting a little, can you get that device a little closer to you? Ma'am, tell me your name, please.
Julianne Trotter.
All right, just keep your voices up nice and loud if you would. I don't know, it's not coming through as strong as it usually does. So I have a plea agreement here that says that the defendant is going to plead guilty to the added count, lesser included offense, I should say, of operating while visibly impaired. The super drunk or high BAC charge would be dismissed. Also, that the defendant is going to plead responsible on count 2 to an amended charge of distracted driving. And the prosecutor then is going to move to dismiss the open intox. Is that right?
That is a correct statement, Your Honor.
Ma'am, is that what you would like to do?
Yes, Judge.
If you plead guilty to operating while impaired, here are the possible penalties. Up to $300 fines, 93 days jail, 360 hours community service, court costs, or all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. If you plead to distracted driving, that's a 0-point civil infraction. You understand that? It won't get reported. Do you understand that?
Yes, Judge.
And then I'm going to dismiss the open intox and the super drunk. You understand that?
Yes, Judge.
I want you to understand that you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the constitutional right to a trial by jury. You could subpoena your own witnesses. You could testify or remain silent. If you remain silent, the fact finder would be instructed that they could not hold that silence against you. If you plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that the people prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, Judge.
You fully understand everything.
Yes, Judge.
To the charge operating while visibly impaired, ma'am, how do you plead?
Guilty.
Were you operating a motor vehicle on West Jefferson near Campo in Brownstown, May 2nd of 26 at 2:30 in the morning?
Yes, Judge.
Prior to that, did you drink alcohol? And if so, what did you drink and how much? Nice and loud for me.
Yes, Judge. I had about 8 bush lights.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes, Judge.
In what way? Why were you pulled over by the police?
I hit a curb and wrecked my truck.
I'm sorry.
She stated she hit a curb, Your Honor.
You hit a curb when you were driving?
Correct, Judge.
Is that right, ma'am?
Yes, Judge.
Was there an accident then?
There was a 1-car accident, her car, Judge.
What did you drive into then, ma'am?
The median.
A what?
The median in the road, Judge. There's a new median on West Jefferson.
All right, so you drove into the median and then the police came to the scene?
Yes.
And were you administered a breathalyzer test at the police station or was this a blood draw?
Blood draw, Judge.
Blood?
Yes, Judge.
And do you stipulate that the reading of 0.205 was an accurate reading for purposes of the plea?
The defense would stipulate, Judge.
I'm sorry, I don't know why I'm having a hard time.
Yes, Judge.
Are you on probation or parole right now, Ms. Trotter?
No.
Anybody force you to plead guilty?
No.
Into the charge of distracted driving, you plead responsible or not responsible?
Responsible.
Plea is accepted to distracted. Plea is accepted. I find it to be an accurate plea, operating while impaired. I'm going to go ahead and dismiss the super drunk charge on motion of the prosecutor, as well as the open intoxicants on motion of the prosecutor. I'm going to refer you for a screening and assessment. They're only requesting 168. I give 2 1/4 on the blood draw, but if that's the extent of their bill, that's what they're going to get. We're gonna have a screening and assessment. You're gonna have to come up here, fill out a questionnaire and be interviewed. Has she been going to AA and did she show you proof of that?
I have seen the sheets, Judge. Yes, she's attending as required under her bond conditions.
All right. I didn't realize the breathalyzer, I don't think, was this high. It's pretty high. I'll still keep it at once a week, but I need full compliance. Do you understand that?
Yes, Judge.
All right, so let's get a sentencing date for you, Mr. Camilleri. What do you have for me, Heather?
July 15th at 8:30.
Is that good with you?
Yes. Yes, Judge.
All right, we'll do July 15th at 8:30. I'm deferring the sentencing on the distracted. I'll sentence you at that time, but I do need you to come up to the court and meet with probation and fill out your questionnaire and be interviewed. Okay, ma'am?
Yes, sir.
All right. You seem very respectful. This is a lot of alcohol. We're going to make sure you don't have a drinking problem, okay? And take care of that, all right?
Yes, sir.
Good luck to you. Thanks, Mr. Camilleri. Have a good day.
Have a good weekend, Judge.
You too. Thank you. Angela, Ardith Rice Day, 26B838848, and B and C. Where I got this one. Your name? Ma'am, you're charged with Animal Vicious Act, and you also have 2 civil infractions, dog at large and no license on the dog. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney? All right, I'm going to provide you with an attorney, and you can go out in the hall, and we'll set you up, and we'll go from there. Okay, thank you. Do I have Scott, Terrell Boyd Scott, 26W842496, 26W842665.
Good morning, Your Honor. Patrick Crawford representing Mr. Scott. Mr. Scott, please state your name for the record.
Terrell Dwight Scott.
This is, okay, so what are we doing here? This says he's going to plead guilty to stalking on file 2496. That's offense date June 25th. They're going to dismiss, if he pleads to that, the trespassing charge on file 26W842665. That's a different offense date. That was April 26th. But it also says here, defendant has 2 new trespassing cases scheduled for July 13th. Somebody wrote down, let us know if you want us to pull them. Who, is that your handwriting, Heather?
Oh, it was mine, and it was directed to Mr. Crawford, or the attorney.
Oh, I see. So I'm just going to go ahead with these 2 now, and then we'll go from there. If you plead guilty to stalking, they've only charged you under local ordinance. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that, sir?
Yes, sir.
If you plead guilty to that, the prosecutor is going to ask me to dismiss, and I will dismiss 26W842665, that trespassing charge. I will also tell you that the possible penalties on this are up to $500 fines, 90 days jail, court costs, or all of those. Do you understand that, sir?
Yes, sir.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. And you have the right to a trial. At a trial, you have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in your own witnesses. If you choose not to testify, that silence would not be held against you at a trial. If you plead guilty, you're waiving your right to a trial of any kind. You're also waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, sir.
All right. Do you have any questions before I ask how you plead?
No, sir.
On June 25 of 20, first of all, to the charge of stalking, how do you plead?
Guilty.
Hang on a second. You act like you're bored.
No, sir.
Is this what you want to do?
Yes, I'll take it. Yes, sir.
Don't act like you're doing anybody any favors. This is important. If you don't
Yes,
want
sir.
to plead guilty, just tell me. We'll stop the process now. If you do, tell me that. Do you want to plead guilty or not?
I plead.
To the charge of stalking, how do you plead?
Guilty.
Were you at or near 25338 Oxford Street in Woodhaven, June 25 of 26 at 3:22 in the morning?
Yes.
And were you at the property of an individual by the name of Christine Weisend?
Yes.
Okay. What did you do that makes you guilty of the offense of stalking?
Knocked on the door.
Crawford, did he do anything else besides knock on the door at 3 o'clock in the morning? He had to, or they shouldn't have charged stalking.
Your Honor, my client showed up at the residence in question after being warned and trespassed several times in the past, and he defiantly showed up at his home and knocked on the doors throughout the night with the knowledge that he was not welcome there by the alleged victim.
The alleged victim was not alleged victim or victim, Christine Wiesand, right?
That is true.
Yes. Okay. Had Christine Wiesand advised you on multiple occasions not to go back to her residence?
I believe you have, yes. I believe so, yes, sir.
Your Honor, to assist my client, I might remind him that the police also told him that he could not return to this property several times in the past. Isn't that true,
Scott,
sir?
if you don't want to plead guilty, we'll set it for trial. I'm not gonna ask you a bunch of questions here. You're gonna tell me yes or no. Did she tell you or did she not tell you on multiple occasions not to go back to her residence?
Yes.
On how many occasions did she tell you not to go back to her residence?
I'm not sure. A few times.
What's a few mean? 10?
About 3.
And did the police also tell you not to go back to her residence?
Yes.
Had you previously dated her? What was the relationship here?
Yes.
So she broke off the relationship. Is that fair?
Can you repeat that? I can't hear you.
Did she break off the relationship?
I think the evictions broke off the relationship, not so much as she or I did.
She tell you that she did not want you to go back to the residence?
Not due to the relationship issues. It was more to the fact more of, I guess, me being evicted from her property or something like that.
Your Honor, if I could assist the court, the alleged victim filed for eviction against my client.
Is that true?
Yes, sir.
So she filed, you guys lived together for a while, right?
Yes.
The property was in her name, correct?
As far as what I seen on the paper, I guess so.
And then she filed a notice to evict you, a 30-day notice to evict you from the property. Is that true?
Yes, sir.
Were you evicted from the property by a judge of this court?
Yes, sir.
Is that in front of me or Judge Hessen?
You, I believe.
Okay. And after that occurred, did you continue to go back in a contact her or appear at her residence?
Yes.
Did she tell you not to come back on several occasions?
Yes.
Did the police tell you not to come back on several occasions?
Yes.
And did you then knock at her door at 3 o'clock in the morning after you'd been warned by her repeatedly not to go back, and after the police had told you on June 25th, specifically at 3:22 in the morning?
Yes.
Probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Is it fair to say that she told you she didn't want you to go back because she wanted to and evict you because she wanted to not have a relationship with you anymore?
Those wasn't the exact words, but I guess it's not fair that I still went.
What's the exact words?
I can't hear you, sir.
What were the exact words?
I'm
feeling like a dentist again, Mr. Crawford. What were the exact words? Why did she tell you she wanted to evict you?
I never really got, well, as far as what the paper says, it said that I was a nuisance to her pregnancy. a nuisance to her pregnancy. I was, I guess you want to say sexually harassing her verbally.
Okay. Why'd you make me sit here and ask you questions for 7 minutes? Please, are you on probation or parole right now?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Something troubled me here, Mr. Crawford. I see the bond I set. I don't usually do that. But I'm gonna order a pre-sentence report. I'm accepting that plea. I'm dismissing the trespass. I'm gonna order, again, you're not to be released until fitted with a GPS tether. You're not to be within 2 miles of her residence or place of employment. You have to be on that tether. You're not to possess firearms or weapons. You're not to enter or go near anywhere near 25338 Oxford and Woodhaven. No contact with prosecution witnesses. No contact with victim. If I find out you're having any contact with her of any kind, whether from there or otherwise, either by text, voicemail, email, letter, contacting her through people, or showing up at or near her residence or place of employment, I'm going to give you a maximum here, sir. Do we understand one another?
Yes, sir.
All right. Trespass is dismissed. Bonds continued. We're going to give you an early sentencing date, and I'll look into this. When can I sentence him, Heather?
We could do July 13th at 1:00.
Good enough. Is that good with you, Mr. Crawford?
Oh,
It
you
is,
know
right?
what? Yeah, I would say we have to. Is Mr. Crawford here that day, or could he Zoom in for the sentencing?
At 1 o'clock, I could Zoom in. I'm not here otherwise. I am here on the 14th.
Heather, cancel any bond conditions that are not common. Well, I guess they all are, but we're going to take them out on the trespass. We're keeping them on the stalking charge. The trespass is now dismissed. That's what we'll do. July 13th at 1. I wish you well. Good luck. We'll see you then, sir. Stay away from that lady. And if there are more trespass charges, I certainly hope that they are not coming in front of me if they involve this victim especially after an order that I gave. That's all I'll say about it. Are they, Heather? Do you know?
Sorry, Judge, my one earbud went out. What was that?
I just want to know if you know whether or not the new trespassing cases involve him contacting her.
I do not know on that, Judge. I can pull them and look real quick if you'd like me to.
They are your cases, and they are scheduled for the 13th. That's the day he's coming back in.
Why don't you stay right there, Mr. Crawford? You stay right there. Bring those files down here, please.
Okay, you want them down? Okay, I'll pull them right now.
I'll go on to another case in the interim. Salvatore Gabriel Damadio, 26B83910A, B, and C.
Good morning, Judge and staff. John Graziani, appearing on behalf of Salvatore McCloud. Please step to the podium, sir. My left, please identify yourself, sir. Salvatore Gabriel, being too.
All right, good morning. Counsel, I need to know, first of all, does he stand mute and wave formally?
Yes, he does.
What kind of a dog is this allegedly?
It's a female German Shepherd that weighs, I believe, approximately 72 pounds.
Does Mr. Damadio have a fenced-in yard?
He does, sir, and everything has been taken care of. This is an unfortunate incident that, in my opinion, has been blown up in proportion. There's, any touching that was done, you nudged, but nonetheless, he's willing to take care of any vet bills, but nonetheless, we, waive a formal rating and stand mute.
Not guilty plea is entered?
We could determine for Judge.
Yeah, I'm gonna give him a personal bond of $500. It says dog on dog attack. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Defendant's dog. Do you have more than one, sir?
No, sir.
It must be in your house. It must be in your house, in a fenced-in area, or on a leash, accompanied by defendant, and equipped with a muzzle. Do you understand that, sir?
Yes, sir.
So otherwise, you're not taking the dog out of your house or the backyard. You understand that? All right, we're gonna give you those.
My eyeglasses are messing with my hearing aids.
No problem. Do you understand everything I said?
The last part kind of cut out on me. I'm
Your
sorry.
dog must be in your house, in a fenced-in yard,
Yes.
or on a leash, accompanied by you and equipped with a muzzle. Do you understand that?
I do, sir.
Okay. And you're not to have any contact with prosecution witnesses. I'll give you a new pretrial date, Mr. Graziani. What do you have for me, Heather?
July 15th at 10 o'clock.
July 15th at 10 a.m. in the morning will be the court date. July 15th at 10 a.m. and you can go down the hall and get your paper notice. And I'm entering pleas of denial on the civil infraction charge.
Okay, thank you so much, Judge.
Thank you.
Thank you, Your Honor.
All right. Peebler, Kyle Stephen Peebler.
Well, he comes up TCF Live on a Wednesday. Just an FYI for everybody, it's actually a pretty slow day out in Courtlandia. So if you haven't figured it out already, we're probably going to do a little less floating around between courts than we normally do. I'm going to continue to ride with McNally for right now.
Okay, your name?
Todd Stephen Mueller, Your Honor.
So this says on the bottom, prosecutor moves to dismiss vicious act as defendant voluntarily euthanized the dog. Prosecutor spoke to victim and was advised that defendant paid all related expenses and she does not wish to make a statement. So they're going to go ahead and dismiss. I'm sorry about your dog. I really am. And I'm going to go ahead and dismiss that vicious act. And then, as I understand it, you are going to plead responsible to one count of dog at large with the understanding that the no license and the vicious act dog charge will be dismissed. Is that right? Can you pull that out and tell me what our fines, the dog at large things are, please? All right, to the charge, dog at large, responsible or not responsible?
Responsible. Yeah.
Judge, it's 135.
I thought so. I'll accept the plea. Fines cost of $135. I'm dismissing pursuant to stipulation on motion of the prosecutor, both the no license charge as well as the vicious act charge. Okay?
Yes, right.
So you can go down the hall, take care of the fines, 135, and you're all set. Best of luck to you, sir. Thank you.
There's also fines on Scott.
All right. Mr. Crawford, can you hear me?
Yes, Your Honor.
I can bring him to you, these to you. These happened after? You better look at these.
I'll come grab the file, Your Honor.
Got Giles, Daniel Curtis Giles.
Yep.
25T6460538. Your name, sir?
Daniel Giles.
All right. You have to pay $200 monthly starting July 1. You're here for time to pay. When can you start paying?
If I could get just a few more months.
Well, I got to get going on this or we're not going to have time to finish it. Where are you working?
I'm not at work yet. I'm still going through physical therapy for my knee.
All right, I got 12 months probation. We started in February, March, April, May, and July. I can start your time I can extend it, allowing you to, you begin on August the 1st, okay?
Okay.
Can you do that?
Yep.
August 1, all right?
All right.
If you need more time, come talk to me, but you're gonna end up having your probation extended if we can't, if you can't pay during the probationary term, all right?
Okay.
Good luck to you.
All right. Thank you.
Zach, Mr. Crawford's looking for those files.
I put them on his desk. He's not
Okay,
there.
he just came in here. Zachary Michael Bowl, 26I-415-321, defendant failed to appear and is responsible as charged by default. Responsible as charged by default. All right. People against Reed, David, Demetrius Miner Reed, 26I-000-1691 and 1692. Good morning, counsel.
Good morning, Your Honor. May it please the Honorable Court, Darnell Barton, P 83363 on behalf of Mr. David Miner Reed. Sir, can you state your name and phone for the record? David Miner Reed.
All right, so for purposes of arraignment, first of all, he has two charges here. Let me just double check. It looks like a super drunk and they alternatively charged OWI. Is that what happened?
That is correct.
And now he stands mute, waits for a reading on both of those. And then as I understand it now, he's going to plead guilty. I'll just put it on count 2, operating while visibly impaired, with the understanding that the OWI will be dismissed and the super drunk will be dismissed. Is that correct?
That is correct.
Is that what you want to do, Mr. Miner Reed?
Yes, Your Honor.
If you plead guilty to operating while impaired, did he execute an advice of rights form today?
I thought they gave me the other business. I'll have them fill it.
Here.
Still. I'm sorry, we haven't filled it.
All right,
My apologies.
that's okay. Just have your, who's that? Your associate or your boss?
He is my boss. So if I may, this is Garrett Washington. He's I'm with the young lawyers section of the state bar, and we're doing a program called Journey to Attorney. So we're helping young folks.
Nice.
I want to get to.
Are you a lawyer now?
Not yet. He just.
You took the bar?
Not yet. He just graduated Oakland University. So.
Oh, so you gotta go to law
He's
school.
going to the bar. Yep. We have a high school graduate.
That's fantastic.
2 that are taking the bar in July.
That's fantastic.
We're hanging in there.
Mr. Miner Reed, just relax. I just am having a conversation here. I hope you didn't take you out to what's this restitution, gross yield, $670?
Yeah, that was.
What's that for?
My understanding was negotiated for the halts that was associated with getting Mr. Miner, but again, I would.
Calling Mr. Wayne. Sir, if you plead guilty to operating while impaired, the possible penalties are as follows. Up to $300 fines, 93 days jail, 360 hours community service, court costs are all 4 points. License suspension, revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
Did you sign an advice of rights?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, Your Honor.
Any questions before I ask how you proceed?
No, Your Honor.
To the charge of operating while impaired, how do you plead?
Yes, Your Honor.
Were you operating a motor vehicle in the township of Grosse Ile on January 10th of 2026?
Yes, Your Honor.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
I believe I had 2 or 3 Jack and Cokes.
What else?
That was it. And then maybe no more than 5. No more than 5 Jack and Cokes.
Okay, you said 2 to 3, and then you said no more than 5.
Yes.
So was it 5 or was it 2?
2 or 3.
It was 5, wasn't it?
It was 2 or 3. So
I'm just asking how much you had to consume. Just relax.
It's okay. What the judge is asking, I think he's saying 5. What the judge is asking is how many drinks do you have? If you're not sure, you're saying it was less than 5, or are you saying it was only 2 to 3? The judge wants to know. So
And you want to be honest with the
Yes, I
judge.
want to be
Some people walk in here a lot to tell you the truth and they're not honest.
Yeah.
And we can read through them.
Yeah.
So just tell me how many drinks you had.
I had 2.
You had 2 Jack and Cokes.
Yes.
Was this at a bar?
Yes.
So you're saying you only had 2 shots of alcohol?
But you were drinking more. The judge is asking, and I know you're nervous.
Don't be nervous.
Very true. Judge is saying not just those drinks. What did you have that entire time? So you had a Jack and Coke, you had some beer, you had a White Claw, whatever it is, let me know so that we can, one, be on the same page and get. I've had 3 Jack and Cokes and I had 3 White Claws.
Okay. It wasn't so hard, was it?
For that BAC, that 2 Jack and Coke does not make sense.
Why were you pulled over by the police? What do you think you did wrong? Forget what they think. I want to know what you think you did wrong.
First of all, give behind the wheel.
I know, but why were you pulled over? You were speeding, weaving, swerving, what
He was
happened?
on the side, he actually pulled over for safety on the side of the road. He was, the officers came up as he was already inside.
Where were you on the side of the road? What street?
I can't remember, Your Honor. I was following my GPS on my way home.
All right, so you pulled over on the side of the road and the officers approached your vehicle?
Yeah.
And did you feel intoxicated at that time?
No, Your Honor.
You didn't? This is a super drunk charge now. Be careful with me. Okay, come on, just tell me the truth.
Yes, Your Honor.
No, I don't want you to lie to me either. I don't want you to guess. This isn't Jeopardy. Stop, listen to me. Just answer my questions truthfully, okay? Your appearance.
Good morning, Your Honor. Matthew Wayne on behalf of the Township of Groseal.
Good morning to you, Mr. Wayne.
Thank you.
So after you had 3 White Claws and 3 Jack and Cokes, you're driving in Groseal Township, right?
Yes, Your Honor.
What bar were you at?
I can't remember, Your Honor.
Was it on Groseal?
I believe so.
You don't know?
Oh, I was just following my GPS, Your Honor.
Were you drinking by yourself or with someone?
I was by myself. I was leaving Captain James.
In Wyandotte?
No, Captain James is in Gibraltar.
And you ended up on Groseal?
Just
Okay,
following my GPS.
okay, and it took you on to Groseal, right?
I believe so.
And,
Oh, I'm sorry. Yes, Your Honor.
and you pulled over because you were kind of feeling at that point that you were lost. Is that true or false?
That's true, Your Honor.
And then you police approached your vehicle, right?
Yes, Your Honor.
And they had put you through field sobriety tests, is that right?
Yes, Your Honor.
And then did they administer a PBT on the road to you, a machine, portable machine?
If I may, Your Honor, they did initially and then didn't register, and then I believe he refused the second time and they tried to. So then they did a blood draw, and that's how.
Is that right?
Correct, Your Honor.
And counsel, what were the results of the blood draw?
I believe it was 0.2. I don't have the exact number, for Your Honor, but we would stipulate to what the session.
3.26, Your Honor, I believe.
I'm sorry?
I believe it's 0.26.
That's correct.
All right.
So stipulate.
And you stipulate that was an accurate read. Counsel, one thing I'm going to ask that they do, so, and I'm not criticizing, I'm going to come back to you here in a second. Not you. On these complaints, I need more information. There's no indication what road he was on. You got BAC of 0.17 or higher. There's no indication what street he was on. There's no indication of what it's just a form. And it really needs to be filled in, these blanks. These officers need to fill these in. They don't have what road he was on. They don't have what his blood or blood or intoxilizer results were. I don't look at police reports. It's inappropriate. Are you on probation or parole right now?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Now, how much did you really? You didn't have just three Jack and Cokes and 3 White Claws and get the 2.6. How much did you really drink?
I've had 5 Jack and Cokes, a couple of shots, and a couple of White Claws. 3 White Claws.
What kind of shots?
I believe they were, honestly, Jameson.
Okay. Why don't you tell me about that before? You're not going to be one of these guys lying to me, are you?
No.
Because a lot of them do. Like, I get the feeling it's either the way I look, talk, or act that most people don't think I'm very intelligent. And I just ask people to be honest with me. You weren't very honest with me. And I don't appreciate that, okay? You made a big mistake. That's really high breathalyzer. You're over 3 times the legal limit. I'm going to accept you're not on probation or parole, you said, correct?
Okay.
Nobody's forced you to plead guilty?
No.
I'll accept your plea to operating while impaired, dismiss the super drunk, dismiss the OWI, and putting the plea on file 692. I'm ordering a screening and assessment. I'm going to set a bond. The only issue I have here is, how are you guys coming up with $670 in false recovery?
Yeah, of course not.
Yeah, but let me see. I can tell you that for decades here, you can hand it right to my reporter. I can tell you for decades here now, I've been capping the breathalyzers at 150 and the blood draws at 2.25. Now, maybe I need to revisit that, but I'm not going to order $670. I mean,
Yeah, I would just submit, I understand that,
it's got $670. He's going to get fined and assessed costs, and I don't appreciate him not being truthful with me. He seems like a real nice kid, to be honest with you. I mean, I've seen a lot worse. But,
I mean, with respect, I don't know, but I mean, aside from the defendant's demeanor, I mean, these are just the figures that the township provided. I mean, I believe they provided in honesty. And these are the rates, Your Honor, and that's what my client has. And I understand if of course, the court is well within its rights to depart from that, but that's,
yeah.
to answer your question, Your Honor.
No. Mr. Wayne, I'm not picking on you. I'm just telling you that I get it. I'm just telling you that I'm not gonna order. Let me ask you a question. You had 3 officers that had spent overtime on the arrest? They were all overtime? Don't answer that. I mean, that's a lot. 3 officers, that's a lot. I mean, so tell them that, you know, I'm not giving more than 2 1/4. And I'm not condoning his conduct. You don't think I'm condoning your conduct, do you? I'm quite sure that we should order a sober link on this.
In Your Honor.
What do you have to say? I'm gonna address bond now. What do you have to say?
Oh, Your Honor, thank you. I was just gonna say, if you'll allow me to allow him to make a statement to you, Honor, whenever we're done with this, I think he wants to address what you just mentioned about not telling the truth, because he is a good guy.
What do you want to say to him?
I just want to say I'm sorry, Your Honor. It was really nervous here at the moment. I'm thinking about my future with my children.
The future of your children.
Future with my children. That's what
Okay, but were you thinking about the future of your children when you were driving around over 3 times the legal limit? That's a good question.
No.
What does he do for a living? I'm just curious.
He's a mechanic.
Use your brains, will you?
Yeah.
Okay.
He's saying that because we had a conversation about.
You cannot, $1,000 personal bond, you cannot leave the state without the consent of the court to violate any law. You must appear in court as directed, attend AA 3 times a week. I want you going 3 times a week. I won't put you on a sober limit. This is the first offense, right? No alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. You don't need to leave the state for any reason, correct?
Oh, yeah.
All right, we'll give you you're gonna then go over to probation, fill out a questionnaire and be interviewed. That's called a screening. And then you're gonna be, or the questionnaire is the screening. And then you're gonna undergo an assessment, and we'll set a sentence date. You'll go over there and you'll get first go down the hall, get your notice. We'll give you a copy of the bond sheet. I'll put you in here. What do you have for me, Heather? This does not have to be on a gross yield day. We can do this any day. I'd prefer to do some of these on Monday when I've got a retained lawyer, when there's no restitution. If you can find a Monday, we'll just do it at 8:30 and.
We have a probation docket on the 20th.
How are you on July 20th at 8:30? Oh. I'm asking your lawyer too.
Judge, I'm sorry, you said July 20th.
Yeah, it's a Monday at 8:30. If you can't do it, you can't do it.
I can't do that. Yeah, I'm
How
sorry.
about the 27th? Am I here then? I think I am. Can you do the 27th?
27, yes, actually, we should.
We'll do it the 27th. Did he hand you an 8A sheet? You're gonna go every 3 times a week. You're gonna have that form signed. And you're gonna come to court, and every time you come to court, you have to bring it with you. You understand all the bond conditions.
Your Honor, I'm sorry. Before you proceed, I was not, because I had to exit the courtroom and return some documents. I wasn't present for the entirety, but I believe is the factual basis of the plea. Regarding the reason, what brought the defendant to the Grossfield Police Department's attention, he was off the road. A portion of his vehicle was jutting onto the highway. I think that's important because that establishes the requisite probable cause for the Grossfield Police Department to investigate.
Is that true, sir?
100%.
Is that true?
Yes, Your Honor.
Don't lie to me again, okay? All right. Good luck. We'll see you back here. Nice. I
Thank you.
think it's great what you're doing for this young man back here.
Thank you, Your Honor.
How long have you been a lawyer now?
2019.
Well, you're well polished for a 6 or 7 year lawyer.
Thank you, sir. I appreciate that.
Have a good day.
Thank you, brother. Prosecutor. Thank you.
It's TCF Live on this first day of July, creeping up on hour 3 now. Bringing you a different show from what we normally bring. To be honest, it's fairly quiet out there in Courtlandia, and I'm going to stay here for 2 reasons. Number 1, with the options I have, McNally's the best show in town. Number 2, notice the first row. The gentleman in suspenders, he's a guy by the last name of Mann, first name of Hoarder. So we're going to hang out at least until we see him.
If you plead here, ma'am, to that, well, you guys got HIDA. You want? No, she's not eligible for HIDA. She checked the box HIDA.
You know what? I apologize, Judge. I meant to take that back in to take.
Yeah, would you do that?
Before
Would you do that real quick? Amy, would you handle that? Just go get that changed. And I'll wait right here for you. Thank you.
Thank you, Judge.
You got that changed?
Yes.
All right. If you plead guilty under section 7411, I'm going to defer the proceedings, set terms and conditions. If you're compliant at the end of that period of time, the prosecutor will move to dismiss and I will dismiss. If you're not compliant, the conviction will enter. Possible penalties on this are up to $500 fines under local ordinance, 90 days jail, costs or all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
All right. You understand everything?
Yes.
For the charged possession of a controlled substance, how do you plead? How do you plead?
Guilty.
Were you on October 13 at 24, 3:41 in the morning on West Road near Telegraph in Brownstown Township?
Where was I?
Well, I'm asking you, were you on West?
Yes.
Near Telegraph in Brownstown on October 13 of 24 at 3:41 in the morning?
Yes.
Were you in a car?
Yeah.
And were you pulled over?
Yes.
Did you have some kind of controlled substance?
Yes.
What did you have?
Cocaine.
Okay. How much cocaine did you have?
Less than 50, which is a very small amount.
Less than 50 grams?
No, less than $50 worth
Okay. And where was the cocaine
in my pocket.
The police confiscated that
Yes, sir.
and it was yours. You put it there, right?
Yes.
Right? Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted. I'll take it under section 7411. I'll refer you, I'm not going to accept it. I'm going to defer the proceeding, refer you for a screening and assessment. You'll be screened and assessed today, sentenced at a later time, okay? Let me see your AA voucher. Or show them to your lawyer. Show them to Ms. Patillo.
Judge, also, I think it's notable that, okay, Judge, I see it.
Okay, so she's been going twice since I told her to on June 15th.
Yeah.
She should have 4 on there, right?
Yeah, she has 4. June 19th, June 24th, June 26th, and June 29th at the Down River Unity.
You're not fooling around with cocaine now, are you?
No, I've been sober for 2 years.
You work?
I'm on unemployment right now.
Where did you last work and when?
Rose, New Boston, and my last day was in April of this year.
What did they do? What did you do there?
I made interior car doors for a Jeep Cherokee.
All right, I'm referring you for the screening assessment. You keep going twice a week. Until that time, you are going to test weekly. I'm adding that provision. You're going to have to go talk to probation. I want you testing weekly. Okay, defendant, you test weekly. So we're going to take her over to probation, Ms. Patillo. Make sure that they set her up for testing, if you would, okay?
Okay.
The sentencing date in this case will be on July the...
We can do the 15th.
At eight-
Can we do this one at 8:45?
Sure, 8:45, okay? Wish you well. Good luck.
Yeah.
Thank you, Judge.
Mr. Crawford brought these other 2 from Scott in, but it looks like he's not in Zoom and I'm in the videos. Here's the other.
Yeah, see, I just wanted to arraign him. He's down on Zoom. Can we get Mr. Scott back on there?
Yeah, I don't know why they took him off because we had one they were supposed to bring on after too.
Crawford, you can go do whatever else it is that you need to do, and when we get him back, we will take care of it. All right, I need the township attorney on Mr. Boyd.
This is just a stick to adjourn that's up for tomorrow.
Okay. I'm gonna go ahead and sign this stip to adjourn, Mr. House sent over, where he's got all these dates, what? You can't. If you have a problem scheduling a date, you tell me, Heather. I'm signing the stip in order. Mr.
Okay.
Boyd, Robert Thomas Boyd, 25B 82557. I'm holding my, crossing my fingers. I'm crossing my fingers, Mr. Boyd, that you did what I asked you to do. I know you didn't let me down this time. I've given you so many chances. Your name?
Yeah, DOB 82378 on behalf of Mr. Boyd.
Your name?
Robert Thomas Boyd.
Your name?
Rob Harris on behalf of Brownstown Township.
Your name?
Caitlin Floyd Carter with Brownsville Township.
Do I dare ask?
Unfortunately, Mr. Boyd has made no progress since the last time we were here. He was also ordered, in addition to cleaning up the property, to at least contact the township to ensure that we did an inspection of the garage tear down. Hopefully he didn't do that. He hasn't contacted the building department whatsoever. Kind of at a standstill here.
Well, Your Honor, the garage was torn down. It is my understanding.
That was before.
We got rid of one trailer.
That was before.
So Judge, I know Your Honor has given Mr. Boyd several chances. He did have a summer cold over the last couple of weeks, so he wasn't able to do anything. But Judge, it's summer, so if he goes to jail, his neighbors, they have to keep looking at that stuff. Your Honor, I would just ask that the court would be willing to give him maybe a week or two just to see what else he can get done. I think if he wouldn't have gotten sick, then maybe he could have contacted the building department to make sure that the property could be inspected, to make sure the garage was torn down properly. But if he goes to jail for 80 days, his neighbors have to sit there for 80 days.
They can start an action. I don't know why you're making my position so difficult, Mr. Boyd. I don't know why. I asked you to get your son here. You said you don't talk to your one son. I asked you to bring your other son. He's not available on Zoom. He's not coming here, is he?
We're on the outs a little. The younger son.
You're on the outs with both of them?
No, my older son dropped me off today.
Why didn't what is your older son? I wanted to talk to him. Remember when I asked you last time to try to get him on Zoom and I think you called him and he wasn't available? Why didn't you just ask him to come in here?
He's working 12 hours a day on midnights.
Can we try to get his son in here next week, Judge, before you decide if Mr. Boyd is going to jail?
I'm not sure you don't.
Get it, Judge. I know this was the cases from April 2025.
But this has been going on for how many years again? 25?
Something like that, Your Honor. I think it dates back to 96.
So it's only been 30 years. This new addition here was built 30 years ago. I don't know what to do with you, Mr. Boyd. At the risk of sounding crazy, I almost feel like I have to order you to get a psychological evaluation at some point.
I'm working on it every chance I get.
Psychological evaluation. I think this is deep rooted. I don't understand it. You could have a nice place there. You're not working on it every chance you get. You didn't call the township. You didn't go to the volunteers. You didn't bring your son in here. You are forcing me to do something I don't want to do. I don't know how much more clear I have been about this or could be about this. I don't know what to do with you, Mr. Boyd. You're the last guy I want to send to jail, but I don't feel like I have a choice. I just don't understand it. I do not understand it. Now I'm gonna hear it's too hot out. It's too hot, and it is too hot. I don't want you out there working on this. I don't think anybody should be working out in this crazy weather right now.
I can work in the morning and.
Mr. Boyd, what do you have on your wrist there?
I got carpal tunnel with both my hands.
You never wore those in here before.
Yeah, well, I wore.
Did you ever wear them in here before? I never saw those on you. How many times do you think you've been in front of me on this case?
I always wear my hurts.
I'm asking you, how many times do you think that you've been in front of me on this case?
I don't know.
Take a wild guess.
5? So wild guess.
I just don't know what to do. This is at least the 10th time.
Wow.
And I bet, oh yeah, I know. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Actually, I think this is the 12th time. Far cry from 5. And all I'm telling you is in the 12 times, I've never seen you wear those bands or wrists. Telling me, I'm just telling you the carpal tunnel syndrome thing I've never seen before. That's why I'm asking.
Yeah. I just wear them when it hurts. If it don't hurt, I don't wear them. Mostly at night.
Heather, put Mr. Crawford in a breakout room with Mr. Scott, will you please?
Okay, Judge.
I'm sorry, I didn't hear you, sir.
Now, I'm going to revoke the 771 status and enter the conviction. I don't have any choice. I don't have any choice. At one point on this case, I remember I did something that had everything that he was left to do, that he had left to do. I need to re-sentence him.
Maybe original sentencing on right.
All right. Why is that not attached? It should be attached to my order. I need you to go to probation if you would. Go to Heather if you need to. Somehow, I need that attachment to the order that I prepared when I sent it. I am revoking your status. I am entering the conviction. I am going to resentence you. But I need to know what I originally had attached, because for whatever reason, it's not attached to the Register of Actions. And then I need you to take a second copy and you tell me what it is that I did or has been completed. And we'll have him back in a little bit. You're just going to have to be patient, Mr. Boyd, okay? Thank you. Okay, good. So we'll want that attached. Can you guys attach that to my sentence, please? And then you're going to give a copy to her that she's going to write on and indicate what has been done exactly, or you guys can, and we'll from there. Thank you.
Thank you, Jay.
Are we ready on Mr. Johnson?
Alrighty, friends, I don't think we're done with him today. I will keep an eye out for his return. TCF Live, hour number 3 now, on a relatively quiet first day of July out in Courtlandia. So again, bringing you a little bit different show than I normally do, not moving around quite as much. But let's get out of Boyd's court for a little while. Let's go see what's going on with Judge Middleton.
Mr. Pelfrey, good morning.
Good morning, sir.
My intention was to have you brought over here to meet with the county prosecutor and the city prosecutor, but it's about 110 degrees back in the lockup, and there are some issues with the patrol car. So I had you brought in by Zoom. Mr. Tim George is here on the city case. It's alleged that on December 6th of 2025, you possess some paraphernalia in the city of Sturgis. That violates the Sturgis ordinance, punishable by up to 90 days in jail and a fine of up to $500. This was connected to a retail fraud charge. You didn't show up in January. They issued a bench warrant. You didn't show up in May of 26, and then you got picked up the other day, and I did your arraignment and set the matter for pretrial for this morning. So you've been in jail in that case for 4 days. You've been in jail in the county illegal entry case for 4 days. So let me. The county prosecutor was here with me. I think she went to get her file. The esteemed Mr. Tim George from Sturgis is here. The public defender left. While we're waiting, well, we talked about this a little bit the other day. Mr. Pelphrey, have you got a place to go if I let you out of jail?
Rips. I've been staying at Rips.
All right. Where is he?
The 206 John Street, Sturgis.
That'd be Mr. Rippy?
Yes.
He had another house which was full of homeless people. How are we doing at 206 John Street, Mr. George?
I'll have to check with Mr. Reed. It's not on my radar, but it doesn't mean it's not.
Well, I hope so. Maybe he's got a legit house and he's got a place for people to stay.
He's got an apartment. Yeah, he sold the house to Christ.
Yes, he did. Mr. George, did you and Abby have a chance to discuss this at all?
I haven't had the opportunity to discuss it with Abby. As Your Honor said, this was a situation where I think it was a retail fraud complaint. They found a pipe on him. I sent the court, I had amended the jurat because the charge on the ticket was incorrect. They did it as like a manufacturer delivery of paraphernalia, but it was just a pipe.
Yes.
Well, I think he already pled to the retail fraud.
It was a civil infraction.
Oh, okay.
So we would just offer the time he's already served and the mandatory fines and costs. With this one, I think it's appropriate based on the circumstances.
All right, the city would offer 4 days jail credit, 4 days for this paraphernalia charge. If you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury. It will not be a trial, understand? If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, I could appoint one for you, or you could hire one. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, I do.
I learned that. I read it on a cup somewhere.
I'm guilty.
All right, so you're gonna admit to that? Did you have some?
Yes, yes, yes.
All right. Well,
To let you know something, shall I let you know something?
Yes.
though?
yeah,
When I was here the last time, you asked me to, if I was trying to get my life back in order. I did go upstairs. I did get my birth certificate going. I did get Social Security going. But my buddy transmission went out and I couldn't make my appointment to get my security card up in St. Kalamazoo. So I'm still holding on that.
all right. Do you think you'll be eligible for Social Security disability?
I don't know. I don't know. I can't find a job nowhere.
Yeah. Make it concurrent with the other case. I'm going to order 4 days jail credit, 4 days, giving 0 days to serve, 0 fine and costs. I'll put the minimum on the other case. While we're waiting for the prosecutor, yeah, it's hard to do anything without a Social Security number. The other case is an illegal entry.
Yes.
And that one, thank you, Mr. George.
Thank you, Your Honor.
Need to fix on base. Well, I had the prosecutor and then she left. Oh, is she? I'm sorry. I didn't realize that. She's zoomed in. There she is. I apologize, Abby. I didn't know. I've never seen your office before. You've got windows and everything. All right, Mr. Pelfrey, this is Abigail Stoll. She's an assistant prosecuting attorney. Abby, we took care of the city ordinance case. The defendant pled to the paraphernalia charge. Mr. George represented that he would offer time served. Let me get back into this case. The cases weren't in the same place because they spelled his name wrong.
But I mean, technicality, you know.
Give me just a minute here, Mr. Pelfrey. All of your offenses basically have to do with being homeless.
Yes. I'm trying my best to get out of there.
That would be good.
All I gotta do, well, I'm thinking about doing if I leave here, is not even walking back to Sturgis. Stay right up here in Sturgis, Centerville, and find a place to sleep in the morning.
Do you need a bus pass?
For what?
To get back to Sturgis?
Yeah, I could. That'd be nice instead of walking.
Well, yeah, it's 5 degrees out. If you get out, you come up here to the courthouse and the bailiffs will give you a bus pass to get back to Sturgis.
I appreciate that. I really do.
Well, let's talk about this case. This is 26467 SM. It's alleged that you did enter without breaking a building at 304 East Chicago Road. You and some other people went in that abandoned house, Christina Wheeler and others, and you were sort of camped out in there.
Yeah, I mean, it was bright and it had electricity. It had electricity in it, and we was cold. We was very cold that night.
All right. Ms. Pelfrey, Mr. George offered time served. In this case, I think it's 5 days rather than 4. Is there a similar offer in this case?
Yes.
Maybe your mic's on mute.
Your Honor, are you gonna put me in a breakout room with the defendant first?
Well, he's willing to plead to the charge. I'm asking if you would simply recommend time served. And that's what Mr. George did. Otherwise, I'll let you speak to him if you'd like to.
That's okay. If he has a few days credit, I believe that's appropriate.
I think he has 5.
Sure.
So
I would
Mr.
agree to that.
The assistant prosecutor would make the same offer as the city attorney did. Time served. In your case, you missed previously, and then this one, you have 5 days of jail credit. So are you willing to plead guilty to that charge of illegally entering that apartment?
Yes, sir.
Mr. Sheets. All right. Now, the prosecutor hadn't heard what we said earlier. Your plan is to stay at a house on John Street in Sturgis. Is that correct?
Yes, sir. I've been helping Mr. Rick. A lot of people take advantage of him because he's such a nice guy and he'll let anybody stay there. But
yes,
I got rights and the manager's allowing me to stay there to keep other people out. When he tried to come up.
I'm gonna work 5 days jail credit, 5 days, $125 of fines and costs. And that is due by August 1. Concurrent with the paraphernalia charge 252831OM. Thank you, Abby. This was saved them having to go get him. Mr. Rippey, you're going to get out of jail. It's very, very hot. It's going to be 95 degrees today. So if you can get from the jail to the courthouse, I'll get you a bus pass to get you back to Sturgis.
Okay.
All right. Stoll, thank you for your help.
Yep. Thank you, Judge.
Thank you.
All right. Mr. Rippey, you're good to go.
Okay.
Alrighty, friends, still waiting for Mr. Boyd to be called back in McNally's court, but he does have a new contestant there in the meantime, so let's go back.
It was my fault.
It's not your fault. You
I
got
just want to indicate what happened is he previously was in an area storage facility that he was not supposed to be in. Where he was arrested at was an open field. That was a misunderstanding. Is that correct, Mr. Fleming?
So I want you to repeat this. We started taking the plea. I agreed to take this under HIDA if there's a factual basis. If I take it under HIDA, I'm going to set terms and conditions, and at the end of the specified period, I'm going to go ahead and dismiss it if you're compliant on motion of the prosecutor, and it's going to be deferred. It's going to be a non-public record for all time so long as you comply. Also, I would go ahead and dismiss the MIP case. Do you understand that?
Yes.
And you understand all your rights on the advice of rights, nice and loud. If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? To the charge of trespassing, how do you plead? On December 23 of 25 at 3:52 in the morning, were you at or near 20260 King Road in the township of Brownstown?
Yes.
And that is what kind of facility?
Over.
Had you been told not to go there?
He hadn't been told, Judge, however, he realized he was with 3 other individuals that were around the area and they were scoping the area, Judge.
For the purpose of committing?
Possible larceny.
Okay.
There have been a lot of.
I got it. Is that true, sir?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty? Please accepted, MIP dismissed. You're not hanging out with the wrong kids, are you? You seem like a nice kid. You're not gonna do silly things that are gonna affect your life, are you? Did he graduate?
Judge, he graduated from Detroit Central High School. He's currently in the process of enrolling with the Job Corps in Flint.
When's the last time he worked?
Last time working was 2025. January.
What happened to your arm?
It's having plans which I broke my foot.
Playing, what, too much what?
Plans in my foot to the
Playing?
Basketball?
playing. You know, I had pick them up. Football.
Pick up what?
Pick them up, mess them up. It's like another game of football.
Pick them up, mess them up? You guys are picking each other up and dropping it?
No, throw the ball in there, catch it, and whoever try to run it.
You gotta get a job, Mr. Fleming. You still work on Meyer, or live on Myers?
He lives on Ardmore with his mother.
Give me the address.
Bath, right over here.
Which is your address?
13282 Ardmore.
And that's in,
The zip code is 48227.
48237?
48227.
Thank you. All right, so you live at 13282 Mardmore. We're gonna set a sentence.
Ardmore.
Yeah, ARDMORE, right? We're gonna set a sentencing date. I don't need a new pretrial date. Just give me a sentencing date. I'll take this under HIDA. We'll go ahead and continue the bond, subject to the bond conditions. What is the sentencing date? The 15th?
Sorry, Judge, I was muted.
Fine.
We could do the 15th or we could do the 16th. We do have Brownstown the 16th also.
Let's do the 16th at 8:30, okay? How'd you get here today? Okay, Mom, keep him out of trouble, will you? He's a nice kid. He's soft-spoken. He can't act like a hoodlum, right? I mean, seriously, come on, get a job. Why aren't you working? Big strong kid.
He's enrolling in the carpentry program.
I know, but he hasn't been working. This is 2026.
Understood.
When did you stop working in 2025?
Right before the new year. Or right, it might have been right after.
Mom, was he working in December of 25?
But he was just working, was that April or March? He was working with my stepfather.
Okay, listen. You're not retired, right?
No.
I mean, you're not a trust fund baby, right?
No.
You didn't win the lottery, right?
No.
Let's get a job quickly. Okay?
Okay.
Well, I mean, when are you gonna get that off?
It's just got on here, so I gotta work. I don't even got the hard S yet. I gotta go get the hard S on
Why
fix.
don't you guys take it easy on each other? That's crazy. You guys are playing a game and you end up with a broken arm. You didn't have to have surgery, did you?
Yeah.
Jeez. Take it easy. You guys are, even you are too old to be doing that. Come on up here, Mr. Boyd. Call in the prosecutor. Good luck. Go down the hall.
Thank you, Judge.
Get your sentence date. We'll see you back here. It's a paper notice. Mom, thanks for bringing him, okay? He seems like a nice kid. Let's get him on the right track, though. You're welcome.
Right.
Right.
2 830s that haven't been brought back up.
Where's 2 830s that haven't been brought back in, Judy?
It's a miracle. I don't know who has
Are they here?
Yes, they checked in and
Well, let's go dig them out. Will you, John, please?
I don't know who his town is.
Call in Ms. Patillo, too. In fact, I'm going to take a 5-minute recess. I need Ms. Patillo on this one, gentlemen and ladies.
I'll get her.
And I'm,
Yeah, well, she was in with County, but it looks like she's out.
we're going to call Mr. Boyd. I know you probably haven't had a chance to go through that. At least I didn't get it, and I don't want it right now. People against Robert Thomas Boyd, 25BA 2557. Mr. Boyd, your name?
Robert Thomas Boyd.
Yeah, Patillo, P8207A on behalf of Mr. Boyd.
Caitlin Foley Carter in the Brownsville Township.
Harris, Brownstown Township.
Do you have a document that you've had a chance to go through from the original sentence that tells me what is and isn't up to the satisfaction of the township?
Yes.
Can you provide me with a copy of that? And have you provided a copy of that to Ms. Patillo?
Ms. Patillo has.
Can I have a copy? I'm not going to sentence him today. I've entered the conviction. I am going to clarify with this. You're telling me, do you have a copy of this?
That's the original copy. I understand that he hasn't complied with any of them technically. I think the only one that's not relevant is book storage.
So when you wrote down F, what does that mean? So he has 2 vehicles parked on the grass still. There's multiple flat tires on the RV in the car. Winter boat storage only permitted on residential waterfront surfaces. You just checked an X there.
It's not relevant right now because not.
Ms. Patillo,
Yes, Judge.
I'm going to have you make a copy of this. We're going to make a copy for you. We're going to make a copy for the prosecutor. This is going in this file. I'd like you to sit and talk with Mr. Boyd. I realize the weather's going to be hot. Mr. Boyd, I'm going to shock you one day because I'm going to have to send you to jail for a long time, and I don't want to do it. I just don't want to do it. How old are you?
28.
You think I relish that? You think I'm a mean guy? I'd have to be a mean guy to want to send somebody to jail who's 78 years old. But you're kind of forcing me. Other, give me 4 weeks out. We're going to make copies of this. I want everybody to take copies, and I want a copy back in the file for me, so we all know what we're talking about. And Mr. Boyd's going to have it all done by July the 29th if we have a date then. I'm setting a sentence. Go ahead.
No, that works, July 29th.
What time?
We're open, Judge, whatever time you want to give them.
8:30. So Ms. Patillo, talk to him. You guys take this. I'm putting it on the top. I'm going to have you get a copy, Ms. Foley Carter and Mr. Harris get a copy, and we're going to leave a file copy in here, and I'll decipher it with everybody, but you're going over it with your client. You know what the prosecutor's asking for, and we'll go from there, okay?
Thank you, Judge.
Mr. Boyd? I know I've threatened you several times. I'm not threatening this time. I'm just telling you that if you don't have it all done, I got to do what I got to do. And I'm going to feel awful about it, but I can't give you any more time, sir. I'm giving you 4 more weeks. That's it. Otherwise, I'm going to have to do what I don't want to do. Ball's in your court. If I had an extra set of keys to the jail, I'd throw them to you. I'm serious. I'm not trying to be funny here. Because you're going to determine whether or not you're going to jail. Good luck. Thank you.
So tune in here at TCF Live on July 29th as we will watch Hoarderman be sent to jail. Because there's no way he's getting stuff done in the next 30 days. Tell me I'm wrong, please. I want to be wrong. Tell me I'm wrong in the chat. But 30 years they've been dealing with this. It ain't happening in 30 days. Just saying. Okie dokie. A few more minutes left here in the 3rd hour of TCF Live. Let's go. Haven't been here in a while. Let's go say good morning to Judge Simpson. See what's going on there.
Fred, your recall is ready. Here is the advice rates.
Court recalls the case of the People versus Michelle Knoll.
Morning again, Your Honor. Raymond Cook for the People.
Good morning again, Your Honor. This is Matthew Mansour on behalf of Miss Michelle Knoll. Michelle, can you please state your name again?
Michelle Knoll.
All right, I'll pick up from where we left off. Miss Knoll, you've now signed or had signed on your behalf an advice of rights form. Is that correct?
Yes, sir.
You have any question regarding any of those rights?
No, Your Honor.
All right. You understand that you're waiving all of those rights, inclusive of the rights under paragraph 5. Ms. Knoll?
Yes, I can hear you. The Zoom keeps
or like freezing, sorry.
Got it. No, it's okay. But you understand that you're waiving all of those rights, including the rights that are contained in paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
Yes, sobriety court probation.
All right,
That's been, go ahead.
Were you on probation in April of this year?
Yes, Your Honor. To answer Ms. Knoll, I got you, Ms. Knoll. So she's in sobriety court, and she's addressed this violation. She's admitted to it, and there's going to be no new violation for this.
So, but I do have to advise you, ma'am, that if this is considered a violation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
I do, Your Honor. I actually graduate tomorrow. So from sobriety court, that's been addressed. As soon as it happened, I told my probation officer immediately.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Ms. Knoll?
Yes, I can hear you.
Did anybody promise you anything other than what's been stated here today to get you to plead?
Guilty?
Well, did anybody promise you anything other than that there would be a fines and cost sentence?
No.
Has anybody threatened you or coerced you in any way to get you to plead? Good morning.
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
I do.
All right. On the date of April 1st, 2026, at the Walmart at 7000 East Michigan Avenue in Pittsfield Township, what'd you do that makes you think that you're guilty?
Well, I attempted to leave the store with property that I did not pay for.
Okay. And this property was property that Walmart was offering for sale?
Yes, Your Honor.
And the store was open to the public? Did you hear that, ma'am?
No.
Was the store open to the public?
Yes, sir.
All right. And you didn't have anybody's permission to take that property, did you?
No, Your Honor.
All right. There's no restitution.
That's correct, Your Honor. As far as I'm aware, all the property was recovered.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor. Thank you.
Ma'am, you graduate sobriety court tomorrow? Ms. Knoll?
Yes, Your Honor. I can hear you.
All right. So you're graduating your sobriety court tomorrow? Is she hearing me?
I think she tried to say yes, but it
Yeah.
cut off on her end. There you go.
Yes,
Okay.
I am graduating tomorrow.
How long have you been in sobriety court?
Tomorrow makes 2 years.
This then was just a hiccup along the way, right?
Yes, sir. I've addressed this. Like I said, I got honest with my probation officer immediately and called my sponsor right after, and we're working on impulse control. And then I sought therapy for like behavioral therapy type stuff. but I'm looking to get another therapist.
Gotcha. All right, anything you want to say before I impose sentence?
I just want to say that I apologize to the court for my actions and my behaviors. I truly feel like the sobriety court program has taught me a lot, and it's just taught me accountability and then the consequences of my behaviors and actions. But it's also taught me a lot about giving myself grace when it comes to matters and mistakes, like hiccups, like you just said. So yeah, that's about it, really.
I don't think you could have summed it up better as to what it's supposed to do, Ms. Knoll.
It's right.
So I'm going to do this. Fines and cost of $250. When do you think you can get that paid?
I can pay that. Can you give me like within the month?
How about I give you to August 31st?
Oh, that's doable. Okay.
All right. Pay it by August 31st, 2026. I'll suspend 90 days in jail, and I'll offer you my heartfelt congratulations on your graduation tomorrow.
Thank you. Thank you so much, Your Honor.
You're welcome. You take care of yourself.
I will. You do the same, okay?
Yes, I will. I did from the hospital. Court calls the case, People versus Grant Ducia, or I know I pronounced it wrong, but day.
Good morning, Assistant General Attorney on behalf of Mr. Day.
Sir, can you state your name, please?
Brad Matthew Duche.
Duche, yeah.
Your Honor, I was unable to meet with Mr. Duce. I'm not really sure how to facilitate that bail. I'm gonna figure that out, if he remains in the hospital.
All right, he's in the hospital at this point.
Right, he's in custody. He's under the jurisdiction of the Washington County Jail,
But he's in, I gotcha. Okay, so why don't I adjourn this then out just to the 15th? And we'll see. 2026 at 9 a.m. All right.
Can I ask him, Your Honor, if he knows how long he's gonna stay?
Well, I don't want to really put his medical out there.
Fair enough.
Why don't, so I'm not going to let him answer. I'm not going to do that. Typically, if you contact the jail, they're going to have a sort of estimation of that kind of thing.
Okay.
All right. Thank you, sir. Be well, please.
Thank you, Your Honor.
That's 10 a.m. So I'll step off, get our 10 o'clock lined up, and then come back. What, Killerwald?
Pardon me?
What? Why are you like scooching around?
I was Judge Washington's court, but I had a 9 o'clock. Mr. Hawker, I'm gonna ask for an adjournment. I have to be in here, it was like at 1 o'clock for a hospice matter.
What is his client in custody?
His client is not in custody.
He's on Zoom.
Is he in?
No, I actually don't have him.
What? That's what I was saying.
Court calls because the counsel was whining with his hand. The cases of the People versus Dean Hawker.
You don't file anything in 0324.
A Conrad Solar on behalf of Pittsfield Township in 073 and 163.
Good morning, I'm Rob J. Kilwell. Judge, I'm on 0324.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Halter and the other matters, 0273 and 163.
Your Honor, I was just
noted that Mr. Bukovich was patiently waiting, but go ahead.
Judge, first of all, I do appreciate you are the most considerate judge I've ever known. So I do appreciate your you being like you are. And I was disappointed yesterday for Mr. Hawter. And if I didn't have this kind of emergency up north, I wouldn't.
I got you. Will the 15th work for you?
Of September. I mean August. What?
He's talking about, yeah.
Who is that?
Unnamed individual.
I believe Mr. Hawter's on.
What's your the person talking now? That's Blue Studio Mini. What's your name?
Yeah, Dean Hutter.
Okay, that's him.
Yeah. Yes.
So you want? No one. You confused. You want the 15th of July or August 5th?
August 5th.
I would also be asking for an adjournment, Your Honor, so.
August 5th. All three matters are adjourned to August 5th, 2029.
Judge, I want to wish you and your staff a happy 4th, and I do appreciate your consideration.
And to you, Mr. For the best. I do. I think so. And I'm going to let the other 7 know you said that. All right. Okay. Anything else I can take care of quickly before somebody else starts whining?
I've got a short adjournment.
Thank you.
If it's Fikowski, no.
You put my name in there?
Of course, going to stand in recess.
All right.
You're welcome.
Just let me know.
Maybe
Right.
Alrighty, friends. So we've got a few minutes left, but there's really not a whole lot of other court to show you. But we are in the Wayback Machine with Judge Simpson, so I'm going to push forward past that and see if we can't get him back on the bench for a few more hearings. By the way, I don't see him in the chat this morning, but I would like to shout out Lone Wolf. So last night, he shouted us out on his live stream and single-handedly got us like an additional 30 subs just in the first few minutes of his live stream. So Lone Wolf, thank you for that. Barbara, if you still have Lone Wolf's link, could you drop that in the chat for me? And if you guys are not subscribed to his channel, he does great courtroom content as well, and I would appreciate it if you all went over there and subbed to him in return. Because I think that would be great. Again, he does good content. He does a nightly show where we do a morning show. So please do check him out. And again, Lone Wolf, thanks for shouting us out yesterday. Yeah, there's the link. Barbara just put that in there. So do me a favor, if you're not already subbed to him, go over and sub to him real quick. Looks like Judge is back now. I got it forwarded to that point. So let's get a couple more hearings from him before we call it a day. We haven't lost audio, by the way. Judge is just still muted. So hopefully he fixes that for us here.
Told me I needed additional information that I didn't have, so I've been held up briefly. I think the records will be helpful in resolving the case.
Is he being held on anything else? I think he is.
He's held on 2 other felonies and several probation violations in circuit court.
Got it. So I'll go to the August 5th date.
Your Honor,
I won't work for him.
I'll actually be out of town that day.
So it'd be a perfect day for me. I have the 15th of this month, but I don't think that'd be enough time for you.
It might be.
You want to try it?
Let's try that if we could, Your Honor.
July 15th, 2026, 9 a.m.
Gotcha.
Thank you. Bond will continue.
Just saying.
Court does call the case of the people versus Joshua Hamlet.
I didn't want to. I think 0253. So on behalf of Pittsfield Township in 0157.
I didn't want to leave you, but.
Good morning, Judge D. Todd Williams on behalf of Joshua Hamlet on the state matter.
Lauren Perry on behalf of Mr. Hamlet on, I think it's 0157, the Pittsfield matter.
Yes. All right. On the state matter, what do we do?
Going to ask this be set for final settlement conference.
Gotcha.
And I told your staff and the prosecutor I'm unavailable in August. I think we're going to move it over to October.
I got no objection to the October date.
So you guys just agreed, and I'm just.
Well, now you can disagree.
All right. So jury final settlement conference will be set. What's the October?
16 tonight.
October 16th, 2026, 9 a.m. Jury selection if necessary. October 19th, 2026 at 8:30. Both of those proceedings are in person. All right. Bond will continue on that case.
Thank you, Judge.
And on the other matter, we have a plea, correct? Plea form indicates that it will be pleading to count 2 of allowing an eligible driver to operate a motor vehicle. The 90-day upon a successful plea of that charge, count 1 would be dismissed. That's court's full understanding.
That's correct, Your Honor.
That is correct.
May I have him sworn?
Solemnly swear to affirm the testimony about the whole truth and nothing but the truth of you, God.
Yes, sir.
State your name.
Joshua Hamlet. Sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an eligible driver to operate a motor vehicle. That is a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that?
Your Honor.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of February 15, 2026, at the location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, Your Honor.
Did you allow someone who is otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Anything you want to tell me before I impose sentence?
Just that I appreciate the opportunity to continue getting my license back fully reinstated so I can enjoy the privileges of having that. Thank you.
All right. Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get that paid?
Within 30 days.
So you can pay before the end of this month?
Yes, sir.
The 31st. Pay by July 31st, 2026.
Thank you.
All right. Thank you, Bond. Continue.
Judge, happy holiday, dude.
And to you.
See you soon, I hope.
Court does call the case. People versus Devon Gibson.
Morning, Your Honor.
Morning, Your Honor. Jonathan Sachs for Mr. Gibson for both his matters, and he is coming up right now.
Evan Gibson.
Thank you. All right. What are we doing?
Your Honor, requesting a final settlement conference for both cases.
All right. You guys are this.
Okay.
Jury final settlement conference will be set August 7th, 2026 at 9 a.m. Jury selection will be set August 10th, 2026 at 8:30. Both of those proceedings are in person.
Your Honor, I apologize. I'm out of town on August 7th.
Is he in custody on something else, or?
He is in custody also on a probation violation. I was going to ask also to address bond, though.
Okay, well, with regard to the August 7th day, the problem's going to be is that we only select
every other month. And so that, and October is a weird in terms of scheduling that because our jury selection doesn't occur until the 19th. And therefore it will be the 16th. It'd be mid-October.
Is there anything in July yet?
What do you mean?
Any opportunity for a final settlement conference in July? No.
Your Honor, I'm wondering if what might work is if we could adjourn this matter 2 weeks to the 15th. His probation case is up tomorrow, is my understanding. From communication with defense counsel, there's indication that the circuit court may release their hold on that case, but we should have an answer by the 15th. And if he is no longer being held on that case, we could address bond on this case and then set it at a later date because he would no longer be or in custody at that point. That way we're not holding him an extra 2 months in custody if we don't need to.
Your Honor,
I apologize.
Your Honor, I think that's a great suggestion. I'd leave it to the court's discretion.
I don't. No.
Will to respond.
Okay. Let me just do this. Why don't I sort of take that suggestion both ways, but what I'll do is I will just adjourn the pretrial out. I'll leave the August dates in place, custody. So I'll adjourn this out to the July 15, 2026 at 9 for a pretrial. I'll leave the August 7th, August 10th dates in place in case it's necessary. And maybe, counsel, what you can do is if things don't resolve on the 15th, rather than delaying his action, you could have somebody appear in your place, in your stead on the 7th.
Yes, Your Honor, I think that will work.
Okay, we'll do it that way. All right, Bond. Oh, go ahead. Did you want to address?
No, Your Honor, I'll wait till the 15th then.
All right, Bond will continue. Let's take this copy.
Alrighty, friends, we're going to go ahead and call it there for the day. Thank you for hanging out with me. I appreciate it. Thank you for everybody's generosity as well today. Lots of donated memberships. Barbara put in a super chat. Very kind of all of you. And again, I appreciate it. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. You can join me a half an hour earlier if you're a channel member on the pre-show. And tomorrow will be a Super Thursday because we will not do a Friday show. We will be taking a 3-day weekend. So the wisdom I leave you with today is from Marcus Aurelius. You have power over your mind, not outside events. Realize this and you will find strength. So please do chew on that as you go about your day. I look forward to seeing you all tomorrow. Take care. God bless.